again, PJS and Newspapers Limited.
Before we start, I should just, for the benefit of anyone in court, or indeed anyone watching, that the names of the people known as PJS, YMA, AB and CD in these proceedings should not in any way be published or discussed. The names of any publication abroad which contains their names or is said to should, in connection with this matter, should not be mentioned or discussed. The nationality of PJS, YMA, AB and CD similarly should not be identified, and nor should anything else which might identify PJS and YMA. Similarly, the name of any blogger or the identity of any blogger featured in the proceedings should not be identified in this connection, and any details of the behaviour covered by the injunction, other than those in the public judgments of the Court of Appeal of 22nd January this year, should not be published, nor should any specific indication as to where material covered by the injunction may be found. So with that indication, I think there are documents available if anyone's in any doubt as to the effect of this. On that basis, perhaps Mr. Brown, you'd open the application of the appeal. And for your assistance and Mr. Miller's assistance, I think the best way to deal with this is to roll up the arguments. So we don't have to have application followed by appeal. We'll hear your arguments.
Thank you very much. That's very helpful. As the court will see from the signatures on our case, I appear for the claimant, the applicant, with Mr. Sherborne, Ms. Skinner and Mr. Adam Speaker, and Mr. Miller, leading Mr. Ben Silverstone, appears for the defendants, the respondent to the appeal. I'm conscious that I need permission to appeal, and that I am directed to address the twin issues of whether the application raises a point of law of general public importance and whether this is a suitable case for determination by the Supreme Court. But let me start by addressing Mr. Miller's contention that there is no arguable point of law. In essence, his contention is the familiar one, that the case is fact-specific and that the traditional respect should be paid to the exercise of the Court of Appeal's discretion. Our reply to that is threefold. Firstly, that the Court of Appeal failed to appreciate or to afford any proper weight to the fact that the tort of misuse of private information protects against intrusion. It's not just concerned with the secrecy of information, as was the case with its predecessor, confidentiality.
I'm not sure.
Predecessor's probably not.
I'm not sure that the latter qualification stands quite the fashion that you've stated it, but that's by the by.
Well, and perhaps predecessor was a slightly tendentious word, but
where confidentiality exists to support personal information in an Argyll-type case, I'm not sure that the considerations that you refer to in relation to Article 8 don't equally form part of the relevant considerations.
Indeed, and the Argyll case was the case to which Lord Keith referred in Spycatcher, in the passage which I think is quoted in your Lordship's book. So can I then just set out go on with the threefold response? The second point that we make is that the court's approach to the factors relevant to the exercise of the discretion and to the weight to be given to those factors was inconsistent as between its judgment in January and that in April. Some of them, in particular the devastating and that's the Court of Appeal's word, not mine, the devastating consequences for the claimant and his children in the event of discharge are just as cogent today as on the 22nd of January. And thirdly, and perhaps most importantly, the exercise of the discretion was flawed by a most significant misreading by the court of section 12.4 of the Human Rights Act. We address that in paragraph 78 and following of our case. Overall, we say, the need for the protection of the information and identity of the claimant may have been diminished, but it has not been extinguished. And so far as the need for protection from intrusion is concerned, that remains at least as great, if not greater, in the light of the events of the past fortnight or so, than it was in January. Can I go straight to the point on section 12? The exercise of the discretion requires a weighing, what Lord Steyn memorably described as an intense focus on the competing rights under Articles 8 and 10. The passage is the familiar one in Res.
You set it out in your...
It's set out,
Okay.
Mr. Miller sets it out,
Yep.
and it's also to be found in Lord Toulson's book. Here we say the exercise of the discretion was vitiated by the Court of Appeal's belief. One finds it set out at paragraph 40 of Lord Justice Jackson's judgment that section 12 of the Act enhances the weight that Article 10 rights carry in the balancing exercise. In other words, he attached significance to the words particular regard and thought that that meant that the feature was to be given added weight. Well, if Lord Justice Jackson were right, it would doubtless have the consequence, as he says in the last sentence of paragraph 40, of raising the hurdle which the claimant must overcome in order to obtain an interim injunction. But it isn't right. Lord Steyn's speech in Res shows that neither article has precedence over the other. I don't suppose the court needs to be taken to Res, but it is in the bundle at Authorities tab 9, and the relevant paragraph is paragraph 17. There are other authorities to the like effect preceding Res, including the... Sorry, does your Lordship want to go to...
No.
There are other authorities making the same point. Lord Phillips's judgment in Ashdown, which we quote at paragraph 81 of our case, is to the same effect. So too the judgment of Lord Justice Buxton in the Court of Appeal in McKennet. That's paragraph 47 in McKennet. And that is Authority Bundle 2, tab 31.
Thank you.
So our starting point is that the assessment that Lord Justice Jackson said at paragraph 46 his court had to make under section 12.3 was invalidated by his misunderstanding of how the words particular regard should be understood. He says the court has to make an assessment under section 12.3 of whether the claimant is likely to obtain a permanent injunction. The court must do so paying particular regard to the factors set out in the Act at 12.4a1 and 2.
Yeah.
So can I now just say something about the competing values here? Two factors in the balancing process remain exactly as they were in January. They are not one jot less weighty than they were at the beginning of the year. And one sees in paragraph 60 of the judgment of the Court of Appeal back in January that one of them was, and I've quoted this already, it's paragraph 60, the fact that the proposed story, if it is published, will be devastating for the claimant. In January, that factor was held to take precedence over the defendant's Article 10 right to publish an account of what had been going on. The second factor, which we say has not been weakened in any way at all, are the best interests of the two children. The court knows their ages, and the need to protect them from harassment, and, to use the words of the court, increased press attention with all that that entails. Doesn't require much imagination to see what that does entail, and that is an issue not just now, but for the future as they grow up and reach their teens.
Could I ask you, Mr. Brown, just for a point of information in relation to that? Under Section 12.4, the court is required to have regard to any relevant privacy code. And Lord Toulson's book, which was mentioned, quotes the Press Complaints Commission's Code of Practice, which contained a provision that in cases involving children under 16, editors must demonstrate an exceptional public interest to override the normally paramount interest of the child. Now, what I'm wondering is that still in force, or is there an equivalent provision in a current code of practice in force?
I believe there is an equivalent provision in the voluntary regulator Ipso's code. Mr. Speaker nods to tell me.
Well, perhaps you can get a copy of that.
Indeed.
Of course, yep.
The code obviously has been drafted to reflect as much as possible the state of the law, and we rely in particular upon what was said in this court in ZH Tanzania in the passage in Lord Kerr's speech, judgment, which is recounted by Lord Justice Ward in the case of Kay and News Group.
Just on your first point, the proposed story, if published, will be devastating. Is that not something where there may have been a change in the light of paragraph 47, particularly subparagraphs 1 and 2 of the current Court of Appeal judgment? Well, they seem to be suggesting there that much of the harm which the injunction was intended to prevent has already occurred. In other words, the other side of the coin would be it would be less devastating future.
Well, perhaps two points in answer to that. And one is there is still a mass of material, particularly that which was published in the US publication, which has not come out, which is sensitive. And the second point, and I'll come on and deal with this in more detail later, relates to the fact that even if the confidentiality or secrecy of the material has been diminished, and I repeat that it has not been extinguished, nevertheless the court failed to have proper regard to the second purpose of the tort, which is to protect against intrusion, against harassment, and against what Mr. Justice Eadie in the CTB case called a cruel and destructive media frenzy. So, looking at the claimant, if it be right, as we submit, that the tort does protect against harassment, the Court of Appeal should have weighed carefully in the balance the potential for future harassment. It didn't. And the storm of harassment, and here perhaps I make a point again in answer to Lord Mance's point to me, the storm of harassment that will follow if the injunction is lifted by this court will be in no way comparable to what in paragraph 47(2) of the judgment Lord Justice Jackson called the excoriation. I think he borrowed the point from Mr. Justice Eadie, the word, of the last 2 weeks. For a start, it will be of a completely different order because PJS will be identified, as will his spouse. Now, the court will have picked up that Lord Justice Jackson twice says at paragraphs 41 and 47 that he adheres to the view expressed in January that the story which News Group intends to publish is likely to be found to be a breach of the claimant's Article 8 rights. But then he goes on to conclude, applying Section 12.3, or thinking that he was applying Section 12.3, that the claimant is not likely to obtain a final injunction.
Yes.
That prediction, we say, is invalidated by the factors I've just mentioned. In CTB, the information was also about adultery. But once it was on the internet and mentioned in the Commons, the need for protection, in the view of Mr. Justice Tugendhat, was actually increased, not diminished. Lord Justice Jackson focused on what he saw as the lessening of the Article 8 right to confidentiality because of the recent publicity, but didn't consider what was likely to happen in terms of press intrusion and harassment once the injunction was lifted. But I just ask the court to go to the two CTB.
Are the relevant passages quoted in your written case?
Yes, and particularly significant is the point that Mr. Justice Tugendhat was making late that evening of the 23rd of May 2011, when he emphasises, it's at tab 21 of the authority's first bundle, that the fact, he says that tens of thousands of people have named the claimant on the internet, confirms that the claimant and his family need protection from intrusion into their private and family life. And then this significant passage.
Sorry, which paragraph?
I'm so
Paragraph
sorry.
3 on tab 21.
Paragraph 3.
Yes, with you.
Yep.
This significant point, the fact that a question has been asked in Parliament, seems to me to increase, not to diminish, the strength of the case that he and his family need that protection. Just if the bundle is still open,
yes,
the relevant passages in the judgment of Mr. Justice Eadie earlier in the day
yes,
it's at the previous tab 20,
yes,
start at paragraph 15.
yes,
At paragraph 16, he asked the question, should the court buckle every time one of its orders meets widespread disobedience or defiance? He distinguishes the decision that he was making in relation to internet publication in the CTB case from his decision in Moseley to allow the continuing publication of a film of the sexual activity there, by saying at paragraph 19, different policy considerations come into play when the court is invited to abandon the protection it has given a litigant on the basis of widespread attempts to render it ineffective. At paragraph 24, taking this quite, he refers to Spycatcher, making the point that Spycatcher is not an analogue because it involved government secrets, and once the secrets were out at all, and the KGB got to know of them, then that was the end of it so far as the protection of the public interest was concerned. Wall-to-wall excoriation is paragraph 24, but you'll see that Mr. Justice Eady, in the preceding paragraph 23, says it is important always to remember that the modern law of privacy is not concerned solely with informational secrets. It is also concerned importantly with, and it's his italics, intrusion. The words that I adopted earlier, a cruel and destructive media frenzy, can be found in paragraph 26. Well, that's PJS. Let's now consider PJS's children. In the judgment earlier this week, it's hard to see that the children were afforded the primacy of importance to which they are entitled. It is true Lord Justice Jackson at 48 deals with this by saying that they will inevitably learn. Well, perhaps that is right, but surely, we argue, it is an integral part of the Article 8 right to family life and the rights of PJS as a parent to determine in conjunction with his spouse when, and above all how, the children will learn, rather than it being thrust on them at their present age. Can I just ask the court to go to K? It's at tab 19 of the authorities bundle.
Yes?
And the relevant paragraph starts on page 1834, paragraph 19. Lady Hale and Lord Mance will remember ZH Tanzania. The passage that we draw attention to in relation to the best interests of the children is that quoted by Lord Justice Ward from the judgment of Lord Kerr, and that's on 1835, running from letter B to letter E. If I can just ask the court to look at that. True it is that Lord Justice Ward, between letters F and G, say that the interests of affected children cannot be treated as a trump card. But on the other hand, for the reasons that Lord Kerr gives and Lady Hale in ZH, it is a factor that, and I quote, must rank higher than any other. The primacy of this consideration needs to be made clear in emphatic terms. We say it appears to have been taken into account in January, but lost sight of earlier this week in the judgment on Monday.
The phrase is a primary consideration, isn't it? Not the primary.
Sorry, did I misquote it?
No, I was just looking at Lord Kerr's
Yes.
passage, and you did say that it was a factor that ranked higher than any others, which is, again, what he said. And I'm not sure that that reflects either what Lord Justice Ward said in the summary or what we've said in other cases.
The words that I would attach significance to is the primacy of the consideration, a primacy of importance.
Well, what we are doing here is giving effect to Article 3.1 of the UN Convention on the Rights of the Child. Now, that has not been expressly incorporated into UK law, but we know that it is to be taken into account when interpreting and applying the Convention rights, which is what we are doing here. And that is the route whereby that becomes part of UK law. And that says, as my Lord has correctly said, that in any decision affecting a child, the best interests of the child shall be a primary consideration. And that's what we were emphasising in ZH Tanzania. It may be fair to say that Lord Kerr went slightly further than the other four members of the court,
the trouble,
but only slightly.
The trouble I would submit is that Lord Justice Jackson didn't go nearly far enough. Seems to have been lost sight of between January and April.
Some research behind me has identified the relevant IPSO
Yes, I got it.
guide, and it refers to an exceptional public interest would need to be demonstrated to override the normally paramount interest of children under 16. It's the very last provision.
Yeah, so I'm grateful to Lord Reid for raising the point. But it chimes to some degree with what we've just been looking at. And as I say, it's not the approach adopted this month. Moving on and looking at the other side of the scales, the defendant's Article 10 right, the critical issue is the extent to which the proposed story contributes to a debate of general interest in society. Sorry, can I just go back to what Lady Hale was putting to me? Of course, there are a number of Strasbourg cases, Appellant in France, which Mr. Miller relies on being a classic example, where the court has regard to the interests of the family, in that case, the bereaved widow of President Mitterrand and his daughter.
Yes,
Yes.
indeed, that's the route whereby
Indeed.
an unincorporated treaty is taken into account in a treaty which is part of UK law.
Yes, I've got there eventually. The defendant's Article 10 rights, satisfying the curiosity of readers about the private lives of well-known people is insufficient. The critical issue, we're told over and again from Strasbourg, is the extent to which the proposed story contributes to a debate of general interest to society. And back in January, in the judgment at paragraph 37, the Court of Appeal cited Couderc in France. The relevant paragraphs for my purposes are paragraphs 100 and 101, and Couderc is to be found in the second bundle of authorities at tab 44.
Thank you. Yeah.
The relevant paragraphs 100 and 101 are on page 32.
Thank you.
100 is expressed in very familiar language, and I won't repeat it. 101 were reminded that Couderc, like this case in CTB, was a case concerned with the alleged extramarital affairs of the claimants. And if the court reads paragraph 101, you'll see it ends with this sentence. The court reiterates in this connection that the public interest cannot be reduced to the public's thirst for information about the private life of others or to the reader's wish for sensationalism or even voyeurism. So my...
Well, then 102 and 103 are also.
Yes. Thank you for pointing it out.
Yes. Yes. Thank you.
My submission, therefore, is that Article 10 would not be engaged at all were it not for such limited right as there was found to be by the Court of Appeal to publish an account of the claimant's adultery. And that is now known about as a result of the January judgment. But
Which paragraph is that in the
January judgment.
January judgment?
I think it's paragraph 60. Would your lordship just forgive me? Is that right?
Yeah.
Yes, it's the last sentence I had in mind, where one sees that in January,
Yep.
the balancing exercise resulted in the claimant's Article 8 right to privacy prevailing over the defendant's Article 10 right to publish an account of its adultery. My submission is that that is a very limited right,
But the basis of the right is what? Is it said that that there is a public interest in newspapers publishing information about the adultery of anyone? Does it depend whether you're a famous person or whether you're an underground driver or assistant or a journalist or a musician? What is the public interest? I find it difficult to reconcile with what the European Court of Human Rights said in the passage you mentioned. It suggests that merely because you don't approve of some private conduct, you're entitled to publish it. There's a public interest in your publishing.
yes, the relevant paragraph is 58, I'm reminded by Mr. Speaker, entitled to publish articles criticising public figures.
So it's linked to being a public figure. Is it
Well, this stage, in the January judgment, it looks as though the Court of Appeal has fallen foul of what I call the Kudak rule.
Just go back to Kudak a moment. I think we get a little further amplification at paragraphs 117 to 120. I think sets out pretty clearly Strasbourg's approach to the relevance of somebody being a public figure, the question of publication of information regarding their private life.
If
117 through to 121, perhaps.
yes, I'm just looking at what seems to be, this is the Strasbourg adjective, a fundamental distinction between reporting details of the private life of an individual and reporting facts capable of contributing to a debate in a democratic society relating to politicians in the exercise of their official function.
They define public figure there, or give the example of political figures or public figures.
Yes.
I doubt in Strasbourg whether you are a public figure simply because you're well known
In the
for
public
some
eye.
activity. I mean, a journalist writing a regular newspaper column is well known, but is there any
Yes.
interest in publishing details of their adultery?
No, and
They talk about political or social scene in paragraph 120, line 6.
but
Not quite sure what the social scene.
But what is important in this context is some of the passages in the unredacted judgment, because in them the Court of Appeal rejected the idea that there was a public appearance which was false and needed correcting. Could I just ask the Court to go to the unredacted judgment? It's at tab 8.
Yeah.
And there are 3 paragraphs. Perhaps one should begin, in fairness to Mr. Miller, paragraph 56, and I'd ask the court to read through to the end of 59.
Right.
It's in tab 8.
I believe we will all have read those paragraphs
Well then,
in the course of our preparation for this case. And speaking for myself, I'm very reluctant that we should talk about it.
Well, you're simply
Well, I'm
asking
not.
us. You're not. You're simply asking us to read.
yes,
Now understand.
Yes.
Yep.
I'm trying to conduct this case
No,
so
no.
you don't have to go
Exactly.
private, as was
Exactly.
necessary in the
No,
court.
you're,
of appeal.
that's why you ask us to read them,
Yes.
and you're not reading them out.
Yes.
Perfectly proper.
Yeah.
Right.
Yep.
I mean, really, there's an inconsistency in the redacted judgment, it seems to me, or potential inconsistency between the paragraph 58, which you were referring to a moment ago, and the preceding paragraph, where they say categorically, the information which it's proposed to publish will not advance the public debate or provide support for any of the competing opinions which are in circulation.
And if one goes back to paragraph 58 in the redacted version,
Yes.
one sees that the conclusion that the defendant is entitled to publish an article criticising the claimant's relationship was simply built on an argument by Mr. Miller, who wasn't there, that the defendant is entitled to publish articles criticising public figures. Well, that in itself doesn't go far enough to justify the conclusion. And the conclusion seems to fall foul of the fact that even those in the public eye are entitled to be protected by Article 8.
But obviously, if it could affect your job,
Yes,
that's a different-
or you were the Archbishop of Canterbury, or you'd given an interview the previous day to a Low magazine claiming how wonderfully faithful you were to your wife.
Yeah, Campbell and
Yes.
MGN type.
Yes.
might
That's
make
what-
a
yes.
difference in all those cases.
Yes. Can I move on to a different point? Devastating consequences, intrusion and harassment. In the judgment earlier this week, the court doesn't clearly focus on the potential for future intrusion, whatever may have appeared in the press in the last few days. And Lord Justice Jackson says this at paragraph 31. He says, one change of circumstance relied upon by a news group can be discarded swiftly. Mr. Miller submits the present case has stimulated a public debate about privacy injunctions, and he quotes. And then Lord Justice Jackson says this: it cannot be permissible for the media to stir up a debate. This is paragraph 31.
Yeah.
To stir up a debate about an injunction to which they are subject, and then rely upon that debate as a ground for setting aside the injunction. I therefore reject this argument. But that is precisely, we say, what has happened here. Once A.B., the mercenary source of the defendants, and I say mercenary because it's accepted that he was offered payment for his story, had gone to the US publication, that very same day, the media here began to whip up a storm. The US publication appeared on, I think, Wednesday. Just forgive me while I check the date.
Well, never mind the date.
Yes,
Yep.
and the same day, the newspapers, The Sun and the Mail, were complaining that their readers could not read what the class of readers, and it's a limited class of readers, could see who bought the US publication. The important thing about the US publication, as the evidence of Mr. Tate shows, is that it wasn't followed up by the mainstream media in the US and doesn't seem to have got into circulation there.
Doesn't this all go back to whether this is a matter of public interest Because if there is some identifiable public interest in the coup d'etat sense, then part of the function of the press is to
Yes.
explore it. And one could call it whipping up public attention. One could say properly drawing it to public attention. If, on the other hand, it's not a matter which gives rise to any public interest debate in the coup d'etat sense, then you say, well, going on and on and on about it can't convert it into something which becomes
Yes.
a matter of public interest.
And what I say is that the perhaps emotive language is justified in this context because there was no public interest, as your Lordship's intervention reminds me of those memorable words of Sir John Donaldson
Quite.
in the Frankham case
Yes.
about the media being vulnerable to treating the interests of themselves and their own readers as coexistent with the public interest.
What's interesting if the public isn't necessarily the same as in the public interest.
Exactly.
Coup d'etat has said much the same, but it's been a familiar theme.
Yes. What was done by the media, and perhaps I'll go into this in a bit more detail later, included directing readers to where they could find the identity of PJS on the social media. One sees that if you go to tab 29 in bundle 2 of the documents.
Yep,
So page 529.
thank you.
So we say, based on paragraph 31, that on Lord Justice Jackson's own approach, little or no weight should have been attached to the recent media publicity. There is another point, and it is this. Lord Justice Jackson's reasoning, we say, is further defective because the failure to appreciate that it would permit the publication of the particularly intrusive details published in a single US publication was fatal to a proper weighing of the balance. I repeat, that US publication wasn't repeated anywhere else in the US, apart, I think I should add, from a community website in one state. Now, that's important because even if Lord Justice Jackson had been right about the right to refer to adultery, it would surely not extend that right to the details of the matters that were canvassed in the unredacted judgment and were also canvassed in the US publication. That publication is in the documents bundle, tab 5, page 142.
Yeah.
And Miss Skinner, in order to avoid us having to go into private, has set out in a schedule the difference between what was published in that article and what has been published here. The usher is kindly distributing.
This is a document, a new document, which is
And it is a confidential.
subject to, exactly.
Yes.
Thank you. It's subject to the
Yes.
confidentiality warning I gave at the beginning. Thank you.
Thank you very much.
So Section A of Miss Skinner's document sets out the details in the public judgment. Section B, those additional details published by the national media in this jurisdiction. And
You mean by published, do you mean in the hard copy press, or do you mean on the internet? Or?
I imagine it's a bit of both.
Yes, it shows us, I think.
It's the national media in this jurisdiction, but I think the answer to the question is both hard copy and online. But doubtless your Lordship asked that question because so much of what we have in the bundles is taken from online rather than hard copies. But I'm not sure that there's any significant difference between the two. And then from pages 4 to 9 of the schedule, the details published elsewhere, which include a blog and 2 Canadian papers. But those Canadian papers are discreet in what they say about the activities, and in the main, the detail which is so sensitive and potentially intrusive comes from the US publication. Well, it's really just something to cast an eye over and perhaps come back to later.
Thank you. Yep, okay. Thank you.
And I now turn to a final injunction, because that's what was the reason the injunction was lifted. The courts believe, applying section 12.3, that it was unlikely we would get a final injunction. I would criticise that for failing to take into account that the current injunction is simply an interlocutory or temporary injunction, and the court should have considered, but did not, the result, if it had been maintained in the period up to trial, and the court, we submit, cannot reliably speculate if the injunction had been maintained to trial, and one would hope a speedy trial, as to how widely the information would be known by the time of trial. So, if the court accepts the submission that a vital part of the tort's purpose and the Article 8 right is to protect against intrusion, as well as the publication of private information, then we submit there's every justification, assuming Lord Justice Jackson's forecast of the result on liability in the claimant's favour comes true, of the court granting a final injunction. And that would have a positive purpose. It would provide some continuing protection for the claimant, his spouse and family, and so far as the children were concerned, it would be particularly important, the long-term view, as they grow up and go through their school days. Can I now just make a couple of points about the general public importance of this application?
Just before you do that, running through the thread of your submissions on a number of points has been this consideration of the issue, to what extent has any confidentiality been lost? And as to the test to be borne in mind when looking at that question, you referred to a number of authorities. You've included in the bundle but haven't referred to Miss Justice Eadie's first instance judgment in McKenderton Ash.
Yes.
There is one paragraph there that's quite often being quoted.
Yes.
It would be helpful to know whether that, in your submission, represents the present state of the law on the subject. It's paragraph 81.
Which tab is it?
It's tab 12 in Authorities 1.
Am I right in thinking that your Lordship quotes that in your book?
I don't know. I may have done.
Mr. Sherborne says yes.
I see.
I'm sorry, I'm conscious of the time, and I've tried to take it as quickly as I can. Your Lordship was asking about 81.
81.
Yes.
I think that I don't recall there's anything in the Court of Appeal's judgment which is inconsistent with that. I just wonder whether that remains a helpful guide or whether that's been overtaken by later authority.
No, it hasn't. Nothing said in the Court of Appeal in any way criticised that approach, and indeed the result in the Court of Appeal was indicative of implicit agreement. I should...
There, of course, that was a confidentiality as well as an Article 8
Indeed.
case.
In one sense, it was an old-fashioned confidentiality case because of the relationship between Miss McKenna and Miss Ash. I see from my note that, in fact, the paragraph 81 in the first instance judgment in McKenna was something that we put into our skeleton argument for the Court of Appeal.
Right.
But doesn't sound as though it did much good, including... Thank you for that.
Anyway, we left it for us to follow, our Lord Tilson to find you in this place. Very well.
As paragraph 81,
Yep.
just quickly, the points of general public importance. This case has been hailed by some as the death knell for the privacy injunction.
Yep.
We hope that reports of its death are exaggerated. But there are 2 points which are significant. The first is this: where an injunction has been granted to protect the personal privacy of the claimant and his family, particularly children, does the accessibility of the information on the internet and social media render the injunction effectively pointless and the court effectively powerless? There's an obvious echo with Spycatcher, but one must, as Lord Phillips pointed out on one occasion, be careful of using that as an analogue because of the separate considerations relating to government secrets, a point that had been made in Canberra before Spycatcher by Sir Anthony Mason in the Fairfax case. The question is, does it, as has been held by a number of experienced judges, do more than protect the secrecy of the information, but also, under the benign influence of Article 8, extend to protection from intrusion and harassment? And it's not that we simply rely on the judgments of Mr. Justice Eadie and Mr. Justice Tugendhat in CTB. I could add a third judge, Mr. Justice Warble, greets those decisions with apparent approval in his textbook, which the court has towards the end of the first authorities bundle. There are also, and I see from my note I was coming on to this, the judgment of Mr. Justice Eadie in McKennet, which Lord Tilson has just drawn attention to, and to Mr. Justice Tugendhat in JIH, which also forms a part of Lord Tilson's book. On top of that, there is the judgment of Mr. Justice Briggs, as he no longer is, in the Rock and Roll and News Group case. That's at Authority 22. And quoted in paragraph 80 of our case are 2 cases in the family division, decisions of Mr. Justice MacDonald and Mr. Justice Baker.
Yes.
Sorry? I'm told by 64, I'm so sorry.
Yeah.
664 in our case.
Yeah, it follows on from the CTB.
Yes.
Yep.
The second point of general public importance is this: where the story which the defendant proposes to publish is acknowledged by the court to be likely to a breach of the claimant's Article 8 rights, and where the disclosure will have devastating consequences for the claimant, is not an injunction the only effective remedy consistent with the protection of those rights? And that raises the issue tackled by Lords Phillips, Clark and Neuberger in Douglas and Hello, its authorities, tab 11, the last 2 pages. In the coda to that judgment, albeit without hearing argument on the point, the court indicated that their brethren at the interlocutory hearing had been wrong to refuse an injunction because relatively small damages were neither an adequate remedy nor a deterrent to a newspaper with a large circulation like the defendant. Effectively, if you allow the claim for damages to proceed and refuse an injunction, you are allowing a newspaper with a large circulation to buy a license to publish. And this is an issue of some importance because the court in Douglas were alive to the importance of deterrence. And normally, I know they don't have exemplary damages in Scotland, but normally exemplary or punitive damages are justified, if they're justified at all, for their deterrent effect. Now, it's been held by Mr. Justice Eadie in the Moseley case that exemplary damages are not available for the tort of breach of privacy because it postdates Rooks and Barnard. And for what it is worth, and this judgment is at, I'll just give the reference, the second authorities bundle 32 at, is it paragraph 32 as well? Paragraph 22.
Well, that's a point we might be asked at some point to consider.
Yes.
So it's not entirely easy to know which way to take it at this stage.
Well,
just going back to, yes, to deal with that point.
Well, I quite accept that. It may come up for decision, but heaven knows if it does, when that will be. And for the moment, the claimant has to proceed on the footing that if he proceeds with his claim for damages to trial, he's not going to get the one thing that might have a deterrent effect, which is exemplary damages. And indeed, it's said in Mr. Justice Warby's book in terms that until that matter is cured, either by Parliament or this court, that remains the law.
On a second point, Douglas and Hello is a rather different case from this because it was a hard-edged case where there was a contractual right, effectively, or at least an entitlement, not to have a publication made other than by the people with whom one had contracted for publication. It wasn't really a concern about privacy, it was a concern about who could disclose private matters.
Well, it was an analogue to this degree that it was also concerned with intrusion, because the point that was being made, at any rate in the House of Lords, was that the publication of the photographs caused distress. But I would say that the present is an a fortiori case because, albeit the facts are not strictly analogous, the potential for distress is just as great, and therefore the need for the court to consider the intrusion that will give rise to that distress is essential.
It's quite a difficult judgment, the intrusion judgment, isn't it? Mr. Justice Eadie in CTV had no doubt that the wall-to-wall excoriation in national newspapers was likely to be significantly more intrusive and distressing than the internet or foreign journal disclosure. Can one... hard copy newspapers, in some respects, might be regarded as less permanent in their in the harm they do, in the intrusion they cause, than the internet, which is subject to deletions,
Well,
effectively permanent.
yes. Well, I understand that point, but in practical terms, one can't distinguish between them, and certainly not in this case. I mean, you can't wrap up fish and chips in internet publications. You can, obviously, with hard copies. And as Mr. Speaker reminds me, all hard copy newspapers publish online. So
Go online. So
I see the point your Lordship's making, but it doesn't, in my submission, have any practical significance. Could I just...
On the damages point, I do think it's very difficult for us to make any assumption about what damages might or might not be available. On the question of exemplary damages, I see that in the book you referred to, I sat on the fence, saying that in worst instances of publication of sensitive personal information, if the court was satisfied the defendant acted in willful disregard of a journalistic code from a cynical calculation that profit would exceed damages, then there remained a case for awarding exemplary damages, but it's something which hasn't yet been further adjudicated. Now, for us to proceed on an assumption that it was or was not potentially available, I think would be inappropriate.
Well, I wouldn't ask your Lordships to forecast what would happen if the matter years hence was to come up before this court.
Yeah.
What I can ask your Lordships to take account of is the position currently confronting PJS, which is that it looks as though exemplary damages, because the tort post-dates Rooks and Barnard would not be awarded, it would require a bold decision by this court to say that they were awarded. It is unlikely that Parliament will intervene, one just doesn't know.
Yeah.
And for the moment, the position is uncertain because your Lordship's on the fence.
Well, it could be said that you're having your cake and eating it. For the purpose of this argument, you're saying we can't get or may not be able to, but no doubt if the matter push came to shove, you'd be arguing you should be entitled to.
Well, perhaps that's
you
right.
Say that
That's
applies,
not having.
You could say that applied. That would apply.
That's not
against
having my cake and eating.
It applies against.
I've
it
just
applies
tried
to the other
to
side,
take a realistic view of the position as today.
And it could be said to apply to the respondent's position too, as a mirror image. I see that.
Yes.
Yep.
Well. But can I just go back to tracing through the intrusion point? Back in May 2000...
That clock is misleading. Mr.
Yes, I know I have to add 15 minutes.
That's right. 16.
Sorry,
16.
yes.
Anyway, never mind.
Sorry, on protection against intrusion, back in May 2007, Lord Nichols in Douglas and Allow in the House of Lords emphasised the distinction between confidence and privacy. And if we look at Authorities 13 at paragraph 255, I think it is.
Page?
Paragraph 255.
Yes. Yep.
Lord Nichols says, you'll want to read the whole paragraph, but that privacy can be invaded by further publication of information or photographs already disclosed to the public.
Yes.
And that's why I don't distinguish between Douglas and Allow being a photograph case and the present case. And that distinction that we've seen in 255 has the consequences explained by Mr. Justice Eadie in that passage in his trial judgment in McKennet, cited by Lord Toulson at page 90 of his book. Basing himself, we've looked at Mr. Justice Eadie and McKennet, basing himself on what Lord Keith had said in Spycatcher back as long ago as October 1988, Mr. Justice Eadie dealt head-on with the situation where personal information has been revealed impermissibly to one set of newspapers or readers within one jurisdiction. And the passage in Spycatcher number 2 is in tab 4 of this authorities bundle. And it's a passage, as I say, from Lord Keith's speech at page 260, between letters F and G. And it's the passage I had in mind when there was earlier reference by Lord Toulson to a case like the Argyll case.
Yeah.
Because when Lord Keith says, tab 4, my Lord.
Thank you. Yep, 260. Yep.
When Lord Keith says at page 260, letter F,
Yep.
it's possible, I think, to envisage cases where, even in the light of widespread publication abroad
Yes.
of certain information,
Oh, yes.
a person whom the information concerned might be entitled to restrain publication by a third party in this country. What he effectively has in mind is not a government secret, but what we would now recognise in the Argyll case as a case of privacy.
Well, that was the passage that Mr. Stevie referred to in his judgment in the Kenneth Act.
Precisely.
He referred to it.
Yes, and one sees that the building blocks coupled later with Lord Nichols in Douglas and Hello. And your Lordship also quotes in your book at page 90 Mr. Justice Toonhart's judgment in JIH, which is at tab 17 of the authorities bundle.
Yep.
The relevant paragraph being on page 193, paragraph 59.
Thank you.
It is just worth, I'd ask the court to read that, because
Yes.
the cases that are cited, Appellant, France, and von Hanover, both support the proposition that there may be interference with Article 8 rights by the repetition in the press of information, even when that information is not secret or unknown. And I've already referred to Plant's protection of the rights of claimant family members. Von Hanover also shows that the court protects against harassment. The von Hanover judgment in Strasbourg in June 2004 is to be found in the second bundle of authorities at, is that it? At tab 29. I ask the court to look at this for one or two familiar passages and one which is perhaps not so familiar.
Yep. Page, paragraph.
Paragraph 50
Thank you.
and 59. 50 is the familiar
401, yep.
approach that private life
Yes.
includes physical and psychological integrity.
Yes.
And
51, legitimate expectation.
yes, and then 59.
And that's the one that,
One sees that what the court was concerned about was a climate of continual harassment. Last sentence of 59,
Yes, I see.
inducing in the person a sense of intrusion amounting almost to persecution.
that's relating to photographs, but you say it isn't limited to
Yes.
photographs. Yes, I see.
But when one has regard to what is likely to be entailed if the injunction is lifted, it's not simply publication in the papers and online. It is also the way in which the media go about preparing and researching a story, which can involve, obviously, paparazzi attention, as in the von Hanover case, the pursuit of members of the family, and so on. One can't be blind to this. And I hope you haven't put it away, but the point I was just going to make is that at paragraph 70, the Strasbourg court makes the point that increased vigilance in protecting private life is necessary to contend with new communication technologies. Well, that was what was said in June 2004. We say that there is no hint of that increased vigilance in the judgment of the Court of Appeal. Rather, in effect, the white flag is run up, the court shrugs its shoulders and says, well, it's a great pity, but in this day and age, there is no more we can do. Can I now just deal with CTB? I'm not going to take you to the authorities themselves, but I want to deal with the way in which Mr. Miller seeks to draw the sting of the two CTB cases, because this is, I think, a point on which he succeeded with Lord Justice Jackson, but the Lord Justice was wrong to accept it, however attractively it was put. What Mr. Miller says is that if you read those judgments, and to be fair to Mr. Justice Tweedmouth, one I think was given at 7:15 in the evening, nowhere do you find a Section 12.4 consideration. No proper account, it is said, is taken of Section 12. Well, just thinking about that for a moment, it is, I'm sure the court will accept, inconceivable that both those very highly experienced judges didn't have the statute present to their minds. They were applying it every day. And if there is a reason why it wasn't mentioned, it's not simply that it was obvious and familiar to them. It is that in both the applications in CTB on that day in May 2011, the very basis of the application was the availability of the information in the public domain. That was taken as a given. So the question for the court was not what had come out or might come out. It was, in the light of what was known to have come out, was there anything left to protect in relation to privacy rights? Was there a need to protect from intrusion? And the answer was yes. So clear why the judgments weren't lengthened by specific reference to Section 12. But even if Mr. Miller's criticism was prima facie right, it is, we would submit, a point which takes him no further, because as Mr. Justice Briggs pointed out in Rock and Roll, and that's in the authorities at tab 22, there is no difference. Paragraphs 21 and 26 of authority tab 22 At 21, he says a series of authorities have established that in relation to the misuse of private information, the relevant equivalent to the public domain defence is that an injunction may be refused if the defendant can show that there's no longer anything by way of privacy left to be protected. And then he sets out the familiar authorities, including, incidentally, Greencorns, which is another case where the court took into account the interests of children.
That was the children's home case.
Exactly, where the addresses of the children's homes were publicly available and where the newspaper had already published them. And they were still restrained from repetition. But the point I just want to refer to is that paragraph 26, where he says that section 12.4a1 creates, in his judgment, no separate or different test from that which I have just described, at least whereas here there's no suggestion the material is about to become available to the public. Well, this is a case where we're looking back rather than simply looking forward.
Yes, I see.
So, I'm sorry. So, this is not a point which, even if it were a good one, which it isn't, would take Mr. Miller any further. Would your lordships just forgive me a moment while I work out what I need to say in the next 20 minutes. Could I just correct one thing in relation to the US publication? Suggested by the defendants that I didn't take the point about the difference between what was published in the States and what was published here. That isn't correct. During the closed hearing in the Court of Appeal, I took the court through the information which had been published in the US in order to demonstrate the significant difference between what was said there and what had been published here. And when we received the Court of Appeal judgment on Monday morning before its hand down, we raised the point in written submissions. And to take it quickly, what we suggested was that paragraph 5A of the injunction banning use or disclosure of the information should stand, but that it should stand together with the public domain exception in paragraph 13, which was the standard provision in the model order in the practice guidance given by Lord Neuberger. So that, with respect, is not a good point against us.
This is what you said in your case, isn't it?
Yes, yes. Can I now just say a little about the facts? The media, we have to say, led by these defendants, energetically assisted by the publishers of the Mail, have embarked, as one sees from the 125 pages of Mr. Carol Ambus's cuttings, on a campaign to ridicule the grant of the injunction with the twin aims of encouraging their readers to find the prohibited information online and thereby putting pressure on the court to lift the injunction. The very situation deplored by Lord Templeman in Spycatcher when he gave, and I'll just give the reference, it's Authorities, tab 3, page 1299.
Thank you.
When Lord Templeman gave as one of his reasons why the interlocutory injunction granted in Spycatcher at the interlocutory stage satisfied the convention, that, quotes, "It cannot now be discharged without surrendering to the press an untrammeled, arbitrary, and irresponsible power to evade any order of the court." Now, I've referred to paragraph 31 in Lord Justice Jackson's judgment, that you can't stir up a debate and then rely on it to set aside the injunction. Just considering that and what followed, it was, we say, wholly inconsistent with that approach for Lord Justice Jackson then, at paragraph 44, to treat the internet and social media as having a life of their own, which the court cannot control. The information on the internet and social media got there because of the very debate about the injunction stirred up by the media, which the Lord Justice had earlier described as impermissible. And here I just need to take you quickly through the chronology. The US publication was on Wednesday, the 6th of April. The source of the American story was the same AB to whom, along with CD, the defendants had offered money for the disclosure of the information. That's admitted in the defense at paragraph 16, tab 12, page 282. The contents, as I've submitted and as Ms. Skinner's schedule shows, went far beyond anything published in the media here. Doubtless on that account, the US publication geo-blocked, it's a hyphenated expression, geo-blocked publication to the UK. And the story was not picked up by the US mainstream media, and no press inquiries were received by the claimant's PR consultant. That's paragraph 8 of Mr. Tate's second confidential witness statement, and I'll just give the reference.
Yes.
It's the second bundle, tab 28, page 523.
Thank you.
In the US publication was effectively ignored. It was the English media, preeminently these defendants and the Mail, who went to town on the story and gave it life. And now if we just go to the main bundle very quickly to go through what happened in the course of the next few days, the very same day as the US publication came out,
Where are we looking now, Mr.
Lord, just getting the bundle. It's
fine.
tab 3 in the evidence bundle, tab 8.
Thank you.
It's the Mail Online, tab 3, page 8, the first in a series of articles by the Mail, Why the Law is an Ass, and it commenced in step with the US publication. Countless Americans can read. One can see how vivid was the hard copy publication. You just flick to tab 5, page 190.
Thank you. Yep.
That's Thursday, the 7th of April. I'm sorry, would you keep that bundle open?
Yes.
And I'll just give the reference. But that same day, Thursday the 7th, at 1:38 p.m., an online Mail journalist called Sam Tomkin incited readers to go on 2 specific social media sites in order to find the name. The tweet, I'm not sure it was a tweet, but at any rate, however he did it, is to be found in the second bundle. Just give the reference at tab 29, page 529.
Okay.
It was taken down after a protest by the claimant's solicitors, to which Mr. Tate refers in paragraph 25 of his first confidential witness statement. Bundle 2, tab 24, page 508. But, and it shows how intransigent has been the conduct of the media, those 2 social media sites were named in the online article posted at 1957 that evening, as you'll see if you go to bundle 2, tab 29, page 530. But going back to tab 3 in the first bundle, Wednesday we have The Law is an Ass, part 1. Friday at page 20, The Law is an Ass, part 2. Saturday, The Law is an Ass, part 3. That's at page 23. And on Saturday, as the court will see at page 26, both the Mail and, as we will see in a moment, the Sun, published some of the underlying information about the protected information, the paddling pool, notwithstanding that, as one sees at tab 3, page 27, they themselves published the warning of the Attorney General about prosecution for contempt. That warning is in the box in the middle of page 27.
Thank you.
On the Sunday, the identity of the claimant emerged in Scotland. The Mail on the Monday gleefully recorded that an unidentified MP was set to name the claimant, as, quotes, British justice plunged further into farce. Fortunately, that threat was defused by the intervention of the Speaker.
Yeah.
The Sun had tried to whip up parliamentary interest by giving their readers something to cut out and send to their MP, asking them to voice the public outcry in Parliament. That's at page 97. The Sun's conduct, I'll just give the highlights, involved on the Friday, as one sees at page 81, giving an interview, publishing an interview by A.B., telling as of his fury that he could be jailed for telling the truth.
That's
And
page
81. my lord.
81, thank you.
There's a pixelated photograph of
Yeah.
Mr. A.B. And at 84, top of page 84, the third and fourth lines, the complaint was that the public here is kept in the dark. Well, it's rather more than a jury point, because Lord Brandon made it in Spycatcher, that the complaint that the public here were being kept in the dark doesn't exactly chime with the argument that the information is all out in the open and the injunction should be lifted. And then on the Saturday, at tab 87,
Page 87, yeah.
I'm so sorry.
That's all right, don't worry.
On the Saturday,
Yeah.
just like the Mail the same morning, details of the sexual activity covered by the injunction are published. The detail of the paddling pool was not in either of the affidavits supplied by A.B. to the Sun. They were back in January. It comes from the US publication, as the court can see if, and I'll just give the reference, you go to tab 5, page 143, the copy of the US publication, it's column 3, and it's the first bullet point.
Thank you.
So, material, we say, covered by the injunction is published presumably in the mistaken belief that it didn't matter so long as the claimant was not named, and material which is taken from the US publication. The court will appreciate that the normal approach in relation to anonymisation of proceedings is a choice between two options: identifying the claimant but restraining details of the protected conduct, or allowing publication of the details but protecting the claimant by anonymisation. What will happen here, should the court lift the injunction, is that PJS will have the worst of both worlds. There's the material about the conduct put there into the public domain, and now it's asked to list his identity. Could I now say something about the true extent of the publicity in this jurisdiction? It's dealt with in Mr. Tate's second confidential witness statement dated Thursday, the 14th of April, a week ago today. It's in the second bundle at tab 28 at page 522, the day before the hearing in the Court of Appeal. Could I ask you to go, again, I'm going to be discreet in asking you what I read.
Just identify the paragraph.
Tab 28 in bundle 2. Thank you.
Yep.
Paragraph 9. Sorry, can I have my bundle?
Yep.
Paragraph 9 at 524.
Yeah. You read that, yeah.
I don't know. Well, anyway, give me that one. You'll see how, despite what's sometimes thought about the intransigence of social media offshore, the two social media are responding, and the agents, the specialist agents employed by PJS, have been able to ensure that a material percentage, they say, of the relevant URLs have been taken down and are no longer active. And the same goes for the body that's referred to also in paragraph 9.
As a matter of interest, is this just taking down the links displayed on a search, or is it actually taking down the original material?
I think it's the former.
So it's a Google Spain type exercise.
Yes, it is. And since Google has been mentioned, can I just say that, as you see at paragraph 9, what is said there is a material number of relevant Google links have now been removed.
Well, Google Spain is the name of the European Court of Justice decision.
Yes. No, well, yes.
I should remind you, you've got 5 minutes, Mr.
Yes, thank you very much. That goes towards dealing with the searches exhibited by Mr. Karalambos at tab 5 of page 183. And what he says in his third witness statement about the searches increasing in number as articles have appeared in the British and foreign media is exactly what one would expect. It doesn't take the case any further forward. The tabloid coverage by these defendants and others was bound to have that effect. So far as Canada is concerned, Mr. Tate at paragraph 6 says that cease and desist letters have been sent. There are two Canadian papers that are referred to. They're at Bundle 2, tab 22, pages 490 and 494, but they were each careful not to publish details of sexual activity. Then there is the blogger. The blog is at tab 5, page 209. It's not a blogger within the jurisdiction. And you'll see from what Mr. Tate says at paragraphs 40 to 41 at page 511 of tab 24, the attitude of the blogger. Finally, there is the Scottish publication.
Yes.
That's at tab 5, page 205, and the publishers of the paper are being dealt with by Scots solicitors. My Lords, that completes the review of the extent of publicity. Would you just give me a moment to look at my notes?
While you're doing that, going back to Article 10 and the appropriate approach to it, you took us to Couder as the latest word from Strasbourg. You took us to a paragraph there that I think you took us to the paragraph which made reference to its rather fuller treatment of Article 10 in Moseley in the UK.
Yes.
We have Moseley and the UK, I see, in the bundle at 38. And am I right in thinking the relevant passage treatment there by the Strasbourg Court is paragraphs 112 through to 117?
Yes, the answer to that is yes. Mr. Sherborne, with his experience, shows that. So, to conclude, why I suggested that this is a suitable case for determination by the Supreme Court is really three reasons. Firstly, the Court needs to consider the practical ramifications of the decision of the Court of Appeal, whether, and I obviously put it in a partisan fashion, they're acceptable in a country under the rule of law rather than the press. The passages in Spycatcher from the judgment of Lords Templeman, Ackner and Brandon are all to the same effect. Lord Templeman said, its authorities 3, I don't ask you to go there, page 1298, letter H, that the court should not, in effect, he said, succumb to the argument that the law may appear ridiculous. The court, he said, cannot exceed its territorial jurisdiction, but the court can prevent the harm which will result from mass circulation within its own jurisdiction. Second point, the court has not considered the nature of the tort of misuse of private information insofar as it does more than merely concern information. And we say that Mr. Justice Tugendhat and the other judges I referred to were right in treating a privacy injunction as having a dual purpose. And we say he adopted the right approach, and if the second of the two purposes is to prevent intrusion or harassment, where the secret is leaked out on the internet, that serves to confirm, indeed even to strengthen the need for injunctive protection from intrusion. And then there are the interests of the children, about which I've said enough.
Yep.
The Sun has accused us of throwing them under the bus.
Yep. Thank you very much, Mr. Brown. Mr. Sherburn.
Thank you very much. I have nothing to add.
Thank you. Mr. Miller.
Sorry, yes.
I wonder if I may start by picking up where my learned friend finished and saying a few words about the facts. I do this, of course, because we're having a rolled-up hearing, so we need to address everything, but also because it's important to appreciate that the basis on which we brought the case back to the Court of Appeal was Section 12(4)(a)(1) of the Human Rights Act.
Yep.
And as the Court is well aware, that contains a very particular form of words, it's has to in the main authorities bundle.
Thank you. Yep.
That applies to any court considering an interim prior restraint order against the press.
Yes.
We see those words that my learned friend referred to, particular regard to the importance of the Convention right to freedom of expression, and where journalistic material is concerned. A1, the extent to which the material has or is about to become available to the public. And of course, the position in April had changed as against the position on the 22nd of January, where there was no information about this matter available to the public. There has been a particular, one might say, an unusual coming together of circumstances here that prompted us to bring the case back to the Court of Appeal. The Court knows the Court of Appeal's redacted, that means its public judgment, which is at tab 9 in the main bundle, page 220, and will have been seen by this court, was promulgated in March. Took a little time to promulgate it because the redactions were extensive and all had to be agreed following the hand-down of the private judgment in January. And this had the facts in it at pages 222 to 223. and it being the first privacy injunction case to have gone to the Court of Appeal in some years, I think 4 years, some interest was taken in the judgment.
Yes.
The facts included that PJS and YMA are married and both well known in the entertainment business. That's paragraph 11.
Yep.
That PJS and AB had occasional sexual encounters starting in 2009. That's paragraph 12. That in December 2011, PJS asked if AB's partner CD was up for a three-way, and a three-way sexual encounter took place. And at paragraph 14, that PJS and YMA have young children. What then happened on the 6th of April is known to the court. The US article is at tab 5, pages 142 to 144. One particular, we would say, unusual feature of this case is that AB, who had given the story to my client, took steps to get it published prominently in the US after the Court of Appeal had made its order on the 22nd of January 2016. This will not always happen. It requires the source for the story to take the initiative in the way that AB did, and it also requires the subject of the story to be of sufficient interest to a US publication, indeed a widely read US publication. Another unusual feature is that the overseas publication carried, as my learned friend has emphasized, effectively the whole story. In other words, everything that we had said to the Court of Appeal that we wanted to publish, and everything that the Court of Appeal had prevented us from publishing. In this respect, the case is very different from CTB, the authority relied upon by my learned friend. There, the newspaper and the source had both been injuncted before the story was published, so that no information had ever gone into the public domain at that stage. The name of CTB as the well-known person who had obtained the injunction then circulated on the internet. And the newspaper made an application to Mr. Justice Eadie on the morning of the 23rd of May 2011 to be allowed to name him. That's all, not to tell the story, but simply to name CTB in light of the discussion on the internet. That is the first CTB judgment which you've been referred to at tab 20. That application was refused by Mr. Justice Eadie, and later that day, an MP named CTB in Parliament.
Yes.
This led to a second unsuccessful application, as you know, later the same day, to vary the injunction, again, simply so as to allow the newspaper to name him. That's tab 22. The article in this case, and I won't ask it to you to turn it up, in the US, page 143 in the main bundle at tab 5, referred to the fact that there had been proceedings to prevent publication of the story in this jurisdiction. So it's right to say the paragraph wrongly suggested it was YMA who had brought the proceedings.
Sorry, what's the reference?
Page 143 in the main bundle.
Yep.
So the American publication,
Yep.
perhaps one might say almost inevitably, drew attention to the fact that the story had been the subject of proceedings in this country. Now, my learned friend asserts the story was not picked up in the US simply because there were no press inquiries. We obviously have no evidence to counter that. If that's what the claimant's evidence is, that's the claimant's evidence. But the evidence, it's fair to say, is very limited on the consequential discussion in the US. It is focused on what's available in this jurisdiction because of the 12.4a(1) point. It's also fair to say that maybe explicable that there is no approach to the claimant in this country by newspapers from America when probably all they will want to do is recycle the story, and they know the story's been injuncted in this country, and a comment is therefore unlikely. I want to turn to what's happened since, however, in this jurisdiction, which is the important point. Dealing first with the internet, initially what happened is all about the World Wide Web and the internet. Mr. Brown, on behalf of the claimant, has suggested, I'm referring to paragraph 42 of his case, that the social media would not have been interested in the story but for the articles in the mainstream UK media in the following days about the publication in the US. We disagree. We say the story took off on the internet in this country and globally on the 6th of April. He also suggests that the fact that some greater interest in the case may have been created by what's been reported in the mainstream media here makes any difference to the issues in this case. This is not an easy issue, it has to be said. There is a lot tangled up, if I can put it that way, in Mr. Brown QC's submissions about the coverage of the issues in this jurisdiction since the 6th of April. Perhaps understandably, he focused on the Mail and my client's newspaper, The Sun, and focused on certain aspects of the coverage in those newspapers. But all of the media, all of the mainstream media in this country has reported the story. He doesn't mention the reports in the Times and the Telegraph and so on, which draw readers' attention to the discussions on the internet following the American publication. And if you turn to, in the main bundle, tab 3, page 64, great, for tab 3, page 64, you will see the passage in a comment piece in The Observer on the Sunday after the article was published in America, which was referred to by the Court of Appeal in its judgment. Second paragraph down, the author says, human inquisitiveness is such that thousands of people have probably searched for this story, which is far quicker to locate, one might add, than anything rumoured to be in the Leveson report. Then would
Page 64.
I'm so sorry, the article 64, 65.
65, it's the Guardian article, page 65.
It's the Observer, it's on the Guardian website.
I see, it's the Observer, yes. But it's first full paragraph on page 65.
65, emphasising how quickly the information can be located on the internet. I give that simply as an example, and to make clear that the media as a whole was discussing this issue of interest to the media. In Spycatcher, which my learned friend has referred to, which is recalled by those of us of a certain vintage, after the book was published in the US, the concern was that the book would be brought by post from booksellers in the US. That would be one route into the country and would be brought into the country by those travelling back from North America. Today, of course, the availability of the information, any information published in the US, in this jurisdiction, is instant and unaffected by the distance between the two countries. It's true that the original article was geo-blocked and could not simply be clicked and opened here, but the information in it, once widely known in the US, was always going to be swiftly available and accessed here. This process was speeded up and expanded and given impetus because of the public profile of JPS and YMA. The availability of the information and the obtaining of the information in this jurisdiction happens in a variety of ways. For example, the information in various forms, but always with JPS and YMA identified, because that is the story when it appears on websites on the internet, moves to websites in North America and around the world that are not geo-blocked. These are found through searches, especially Google searches, and read here. For an example of a North American online publication that has identified the claimant with reference to specific parts of the confidential information, and is, I understand, still available here, see page 493 in the main bundle.
I think it's in the next envelope. Or is it separate? 493 is in tab 22 of the second bundle. Yeah, second bundle, yeah. Yep.
Just by the bottom hole punch. And you'll see the publication referred to on 492 at the top right-hand corner. Very well-known publication on the web.
Yes, yes.
Both in print and on the web. So that's the first route, information being recycled on websites, media organization websites, following the publication in America. Secondly, the information is circulated and discussed on social media here. For example, Twitter, Facebook, and Instagram, which are heavily used both in North America and here, as the court will know. As the court will also know, this process often involves information being sent to and appearing on your device, rather than being searched for. That's what happens with material published by Facebook friends and tweets.
Yep.
It's then passed on in ever-expanding numbers and quantities. It mushrooms out onto the internet. If you look at tab 6 in the main bundle, again in a confidential exhibit, so I'll simply take you to the page.
Thank you.
Say a word about it.
Yep.
Page 170.
I think that's tab 5, actually. Yep.
I'm so sorry.
Anyway, it's page 170.
Tab 5, I do
It's
apologize.
page 170, that's the
Page
one.
170.
Yep. Thank you. Yep.
In the middle of the page, this
Yes.
is a Twitter hashtag.
Yes,
and
I see.
You can see, following up from the bottom,
Yep.
what is happening regarding
Yep.
discussion. It's been going on since the publication of the public judgment in March. What one then gets in the middle of the page on April the 6th
Yeah, we can see that.
is immediately on April the 6th,
Yeah, we can see
is
that.
the recycling by way of tweeting of the
Yep.
original promotional
Yeah,
material
we can see that. Yep.
for the US publication.
Yes, we can see that.
This is not something a court can prevent. This is not something a court can prevent.
Understand.
The process continues over a period. One type of dissemination, one of the two types of dissemination, feeds the other. You pick up information on the internet, you may search for more on the web. If you pick up some information on the web, you may discuss it on social media. Some of the publication on the internet is explicitly by way of protest at the operation of the injunction in this jurisdiction. See most notably the article on the 11th of April 2016, which you were taken to, of the well-known offshore blogger, which was published here and is heavily, it's a blog which is read here. It's published offshore, but it's read here, and a well-known blog. That's at page 210. I think you've looked at it. So I'll simply make
we were taken to it, but anyway, we have it.
Yeah.
Thank you.
That's a protest, and it published a summary, what it described as a summary of the US article.
Yeah.
It is available online here, and it contains, in the summary, some of the details of the story.
Yes.
It's impossible to quantify with any precision how many people now know the story. The court trying to assess this has to look at the available evidence, as the Court of Appeal did, and draw inferences as to the extent of dissemination, taking into account how the internet and the World Wide Web works. But we were able to put before the Court of Appeal trending information from Google in this jurisdiction. These are Google search details regarding trending of certain terms. And if you turn to page 517 in the bundle,
Yes.
you'll see a graph from the Google records showing how searches against the name of the claimant increased dramatically through Google searches in the days after the publication of the North American article. And if you look at the following pages in that exhibit, you will see that the same is true of searches, was true of searches against YMA's name and the name of the US publication. So you can never actually get numbers. It's not possible, it doesn't work like that. But you can get trends and you can get indication of trends. And that is powerful evidence that very large numbers of people availed themselves of the information that was available on the internet. Can I just say a word about consequential discussion in this jurisdiction? The dissemination of the information is not simply about the World Wide Web and the internet. People do still talk, if I can put it that way. It's easy to forget that they do, but they communicate in pubs and in cafes and in over the garden fence and so on. Once a story has currency on the internet, it does become the subject of discussions between people in the jurisdiction. Again, that is an obvious fact, and that has happened and will have happened here. Both forms of dissemination and discussion have been increased by the litigation process and reports in the mainstream media about it, which do not breach the injunction, but which discuss the issues raised by the case. And of course, publication has come close to this jurisdiction when on the 10th of April, the Sunday after the American publication, a Scottish newspaper, again by way of protest, published details of the case with reference to the name of the claimant and his ability to fund the application. And you were taken to that in tab 5 at page 205.
Thank you.
So the evidence stops at 14th of April 2016. That is the evening before the hearing in the Court of Appeal last Friday on the 15th. But all of this continues to a degree and could be evidenced if need be. It doesn't just stop because I stood up and opened an application in the Court of Appeal on the 15th. Again, the litigation over the last week has increased interest and discussion in the mainstream media, both on the internet and generally, and that will have fueled the accessing of the information that's prohibited. Can I turn to what will happen now, as it were, between now and the trial if the interim injunction is maintained? It is likely, we say, there will be more national and international news spikes about this story, which will carry with them more discussion and dissemination on the internet of the information covered by the injunction. Mr. Brown QC says you cannot speculate about this, and that's right, but you can draw inferences from the evidence that's available to you and what is knowledge and matters that you can take judicial notice of. The whole process can be very difficult. We accept that. And you will see and have been taken to in the cases, courts reaching inferences about wall-to-wall excoriation, to use the CTB expression, in the event that an injunction is lifted. We would say that sort of observation has some elements of speculation and maybe some elements of exaggeration. But it does show that the courts will look ahead and project to the best ability they can, what will happen in the future if an injunction is lifted. In that instance, it's to the disadvantage of the newspaper and the argument of the newspaper, but it may well be that we're entitled to rely on what will happen in the future to our advantage.
As a matter of construction, the statute, when Section 12A 1 requires the court to have regard to the extent to which material is or is about to become available to the public, that could be taken as reference to the Thatcher Diaries type of situation where there was planned publication in any event. Or it could, I suppose, be treated as an invitation to speculate what is likely to happen. Are you contending that as a matter of construction it means the latter?
I wouldn't use the word speculate. I've tried to emphasise that obviously the court want to avoid that, but...
About to become available suggests a certain degree of immediacy. Forming a view as to what will happen over a period of weeks, depending on what other developments there are, is rather different, and it's a little difficult to see how a court could do it. But I would just be helped by knowing what you say is the proper way to approach the construction of that provision of the Act.
Well, we say it would have to be interpreted broadly, since the exercise is to look at, as the Court of Appeal noted, what is to evaluate what is likely to happen at the trial. So there is a period between the obtaining of the prior restraint injunction at the interim stage and the anticipated trial. And it is within that period that more information may become available to the public.
Section 12.4 merely identifies the things to which the court must in particular have regard, but it doesn't exclude the court having regard to other matters.
Not at all, no. No. And it seems to us the wording is framed to cover the moment of the original application for the interim restraint order. In our case, the hearing before Mr. Justice Cranston on the Friday night, but the court may, in different types of cases like this one, have to project further into the future and look at what is likely to happen between now and the trial. That is our submission.
You say that's inherent in the exercise required under Section 12.3?
It's inherent in the exercise, and it's necessary as part of the evaluation of the Article 10 and Article 8.
So the court doesn't say, would we, if we were sitting today, would it be likely that we would grant a final injunction?
No, exactly.
It says, casting forward to when the hearing's likely to take place, is that likely to happen then? And that inevitably involves a degree of, you don't like calling it speculation, but evaluation.
Yes.
Okay.
And this is a very particular situation we're in. We're not at the first stage where the injunction is being applied for. Some months have passed. Yeah. We're in between the injunction and the trial, and the media is put in a very difficult position if material does become available publicly, progressively and continuously over the internet, because you have to decide, when do we come back before the court and raise the issue of the availability of the material on the internet? And how often do we do it? Do we keep coming back as the information becomes yet more available, if that's the case? So the court could theoretically be facing applications continuously to discharge injunctions like this, where there is an evolving story and more material is appearing on the internet. That's obviously undesirable. So at certain key points in the tale, as it were, we would suggest the court has to take stock and take a pragmatic view, a realistic view about what has happened, what's going to happen in the future, and what's going to happen at trial. That's what the Court of Appeal said, and with respect, we think they were right about that.
Are you able to estimate when a trial might be held?
The defence has gone in. We would hope before the end of the year. There's not a lot in the case, as the Court of Appeal judgment makes clear. I mean, it's that there are few protagonists, not many documents. So it's not a case that would take long to get to trial, one wouldn't have thought, subject to any interlocutory applications. The litigation process will cause some of the news spikes that I've spoken about, so will more general discussions about our law of privacy and injunctions. I mentioned this in the Court of Appeal, and I say it again. In relation to the Culture Secretary last week, there was an event which prompted a lot of discussion about how our law of privacy works. When those cases come up, certain well-known cases get discussed. CTB, in the name of the actual claimant, which is the currency of the case in the public domain, gets discussed all the time now. Maybe this case will take over and PJS will become the case that's discussed in the context of information becoming available to the public. But every time there is one of those cases, this case will be referred back to, and what is available on the internet will be available to be searched. Similarly, publicity...
Well, will it? I mean, how do we evaluate that? Mr. Brown says that his clients, his solicitors say they've been quite successful in removing, at any rate, search answers or links, so that how far can one say that the internet is going to continue to be readily available as a source of information about this, if he's right?
Well, with respect, that evidence is fairly limited, and we would say is a little unrealistic as to how the internet works. Twitter, I don't think, have responded to the inquiries. These are mainly American-based service providers that tend to work to the First Amendment. The way Twitter works, of course, is that you set up a new hashtag and a new string of comments appears. If you take one down, another one can appear when a new news event occurs and a new news spike occurs. So you are constantly trying to put your finger in a hole in the dike as the water comes through. That's the problem. And when I speak of a news spike and consequent discussion, it's not so much a question of going back to what's already there, although material hasn't been taken down that is available and can be looked at whenever people want to. It's more that new threads will be created. There will simply be new discussion, and the information will be recycled. The problem, or the issue, is the fact that a proportion of people in this country now know the information, and they can put it out again on the internet.
Looking at it the other way around, the difficulty from your point of view is perhaps that you are undoubtedly seeking to add something. Otherwise you wouldn't be here. You're seeking to add more information, seeking to access more people. Have we seen a statistic that 20% of male readers know?
Yes, it's quoted in the judgment.
Yes.
Yes.
So, I mean, you are undoubtedly, or do you, perhaps you would address this point, you are undoubtedly seeking to expand the available information in a way which will presumably attract readers.
Yes, and that's the way the claimant would put it. But what we would say, and what a journalist or the media would say, is at the moment we're inhibited from discussing something that everybody else is discussing, and that's not a healthy state of affairs.
Well, you'll come to the authorities later. I mean, on the authorities, the problem you face is that the argument that what you're seeking to discuss is something which, in Strasbourg law terms, is not permitted to be discussed, or it shouldn't be discussed, without a breach.
Sorry.
Without a breach?
Yes.
No, absolutely. But that's why we came back to try and get the injunction discharged. I mean, the one thing that is important to stress on behalf of...
No, without a breach of the convention.
Without a breach of the convention?
Yes.
Well, whether there is a breach of the convention depends on the Balancing Act. Because the Balancing Act arises from the positive obligation of the state. What was said in von Hanover is the state and the courts must protect both rights. Neither have precedence, as my learned friend points out. So when there is horizontal engagement of the convention between two private entities, well, you know the argument.
Yes. Well, anyway, we're going to come to that
so
later.
It begs the question of, it's not so much whether the state is violating it, begs the question of whether we should be allowed to do it, given the need to do the balancing exercise and apply section 12.4a1. That's the issue. That's the issue the Court of Appeal was looking at. That's the issue we took back to the Court of Appeal. And I was just going to say, it is important to appreciate, and all the criticism that's gone on of the press in this case, and goes on in the post-Leveson era, that my client did notify, did go through the injunction process, which in years gone by would not have happened.
That's perfectly fair.
And has tried not to break the injunction and has gone back to the Court of Appeal to try and lift the injunction.
It's perfectly true. You're played by the rules.
Yes, thank you. So, just to sum up, the story in January has now, that didn't get published, has now become intertwined through the published judgment, websites, social media, with public discussion about this litigation and the ongoing discussion, more general discussion about how our developing law of privacy operates. This happened to an extent when the redacted judgment was published, but it's become much more substantial in the last 10 days and has added fresh public interest to finding out about and discussing the story. And we repeat that a court order cannot prevent any of this happening. That is the reality. Turning to the law, as far as the question of what Section 12 requires the court to do is concerned, which we've touched on, we don't have a great deal to say on that because the statutory words speak for themselves. All we really want to emphasise is the need for a court in the situation the Court of Appeal was to focus on the statutory words and apply them. The statutory words require the court to, that's 12.3, to project itself forward to the point of trial and to consider that very specific question, not will the claimant win at trial, but is permanent relief likely to be granted to restrain publication at trial. This is a tricky exercise to do when you're factoring in the balancing exercise under 8 and 10. The balancing exercise is difficult enough to do at a trial, but to project ahead to how a judge will do it in 6 months' time is particularly difficult. But it has to be done, and you have to look ahead to what the arguments will be under 8 and 10, including under subsection 4A1 at the time of the trial. How will things have evolved to that point? What will each side be saying about the availability of the information to the public at that point? That's why you have to look at what happens between now and the trial if the injunction is maintained. Each case will turn on its own facts. That's an obvious proposition. But there is some value in looking at the cases. A couple of the cases, my learned friend has done so. The one Strasbourg case we haven't looked at, which may be important on a couple of points of principle, I can deal with it very briefly, is the Additions Plon case at tab 8
Thank you.
In the main bundle. Now, I emphasise every case has a completely different set of facts, and I'm not suggesting the facts of this case across the piece are comparable to this case. But as you know, the way Strasbourg works, we look for particular principles in the decided cases, draw them out and see if they have any application in the case before the court.
And when we're looking at these Article 8, Article 10 issues, we have to keep in mind there are two separate questions, aren't there? One is whether publication is lawful in convention terms, and the other is whether, if not, an injunction is an appropriate remedy against it.
Exactly.
Each involves a separate set of considerations.
Exactly.
Yep.
And I'm going to come on to that, but let me take Plom very shortly because it's a well-known case. What happened in Plom was that an interim injunction was granted to prevent publication of a book about the medical treatment of President Mitterrand. There had been some publication prior to the interim injunction, so prior to what was our application before Mr. Justice Cranston. It was then halted by the grant of interim prior restraint on the basis that the published material, if it continued to be published, would be a serious intrusion into the private family life of the family. That's paragraph 9 at page 710.
Yep.
The interim injunction was then upheld on appeal in March 1996, so 3 months later, and the case progressed to trial. You can see that at page 712, paragraph 14. The widow and the children of the deceased president pursued civil proceedings, as is happening in this case, in which they were seeking a permanent injunction and damages, as here. Again, they asserted their own privacy rights, even though the book was about a family member. The permanent injunction was granted on the 23rd of October 1996, and if you look at page 715, in the extract from the judgment of the trial court, you will see right in the middle of the page that the book had had an initial print run before the prior restraint order, the early prior restraint order of 40,000 copies. It says 40,000 copies were distributed and sold from the 17th of January in the few days before the injunction. You can also see at the bottom of page 715 that the trial court said this: although in spite of the injunctions of the 18th and the 13th of March 1996 prohibiting distribution of the book, information contained in Le Grand Secret, which was the name of the book, has been divulged through various media. The ensuing situation is not capable of preventing the injury and damage that would result for the claimants from resumed distribution of the book, with the particular light which comments of the doctor, that's the presence doctor, shed not only on relations with members of the family circle, but also the most intimate reactions of the president to his illness. In Strasbourg, the court was told, if you turn over to page 718, for appeals against the permanent injunction failed, which was why the case got to Strasbourg. Top of page 718, paragraph 17, the parties have stated that an electronic version of the text of the book is available on the internet. They have not indicated who decided to disseminate the text in this form or the date on which it became available. The court at paragraph 40 in the submissions of the parties, some more facts emerge. In the middle of the page at 727, the information in the book, this is the submissions of the applicant company, the publishing company that wanted to publish the book, submitted the information that had been very widely disseminated. There had been an advanced publication of extracts in the January the 16th, 1996 issue of Paris Match, so some information had been put out in a magazine. 1 million copies sold. 40,000 copies of the book, as we know, had been sold before the urgent applications judge had ordered the discontinuation of its distribution, and by March the 13th, 1996, when the Court of Appeal had decided to maintain the injunction, the book had been disseminated on the internet and had been the subject of considerable media comment. So one can see the parallels to the case here. The interference with Article 10 was justified by the French state on the basis of under Article 10.2, on the basis of the protection of the rights of others, namely the widow and the children of the deceased president. So the information was intrusive, it was private, and their rights were in play as a means of justifying the injunctions that had been granted. At paragraph 45, the court emphasised that a distinction had to be made, this is at the bottom of 729, between the interim injunction and the measures taken in the main proceedings. It reiterates in this connection that the need to interfere with freedom of expression may be present initially, yet subsequently cease to exist. The ruling of the court under the necessity for the measure, which, as is often the case under Article 10, was the issue, were the injunctions necessary in a democratic society. The ruling was, and you'll see this at paragraph 48, that the interim injunction was found not to be a violation of the publisher's rights. In other words, it was justified in pursuance of the Article 8 rights of the family. Similarly, see paragraph 50, the order to pay damages at trial was also not a violation of the publisher's Article 10 rights, but he took a very different view about the permanent injunction. This was for a variety of reasons, but in part because of the matters at the bottom of page 732 and the top of 733 in paragraph 53. The court said, passage of time, this is after the grant of the earlier interim injunction, must be taken into account in assessing whether such a serious measure as banning a book, a measure which in the instant case was likewise general and absolute, was compatible with freedom of expression. Furthermore, by the time of the civil court's ruling on the merits, that's at the trial, Not only had some 40,000 copies of the book already been sold, but it had also been disseminated on the internet and had been the subject of considerable media comment. Accordingly, by that stage, the information in the book was to a large extent no longer confidential in practice. Consequently, the preservation of medical confidentiality could no longer constitute an overriding requirement. So, the court decided, in effect, that...
Well, there were a number of factors, because by the time the final injunction was granted, there had been the degree of dissemination which you referred to, which incidentally had been at the time of the interlocutory injunction which they approved, but also there had been a damages award and also a criminal penalty. And
there was the paragraph 53.2.
And in all, they considered that when you've given awarded damage, when there's been a period of prevention of publication to enable the family to come to terms with the publication of the medical details about their deceased father, oblique stroke husband. So they had time to adjust to that. They'd had a damages award, and they had the satisfaction, in inverted commas, of a criminal penalty.
Yes.
That it didn't require additionally a permanent injunction.
Yes, absolutely. Yeah. I'm not going to hide from the fact there were other factors.
No, you made that point very fairly before we turned to the judgment.
But basically, the interim injunction was only for 1 month, as Lord Toulson says.
No, it was continued.
Continued for 9
It was
months.
upheld in March and continued through the trial.
The grant and the continuation were both that lawful.
Ah, yes.
It was the final injunction.
So this is the best I think this is an unusual situation. This is the best I think we get in Strasbourg.
You're quite right to refer us to it, I understand.
There are some other cases referring to national security, but this is one about privacy.
Yeah.
So under Section 12.3, the court has to cast itself forward to this point of the possible permanent injunction, rather than looking backwards, as the ECHR does, European Court of Human Rights does, when it's reviewing the compatibility of the permanent injunction. But the issue is the same in Article 10 terms. Is the permanent injunction a justifiable prior restraint to protect the privacy rights on the facts? Yeah. And a permanent injunction is more dramatic than a temporary injunction. That is obvious. It's a wider restriction on freedom of speech. It means these matters, presumptively, can never be discussed at all. A similar conclusion to that reached by the Court of Appeal in this case was reached by Mr. Justice Eadie not in the main Moseley case, but in the early Moseley case relating to an interim injunction. That's at tab 14 in the main bundle. This was the case about a clip of the sex party on the website of the News of the World on the day of publication, Sunday the 30th of March 2008. The clip, the 5-second clip, was up for about 24 hours into the Monday, the 31st, when it was taken down. Mr. Moseley wanted an injunction to prevent it being put back up, and the case came before Mr. Justice Eadie in the middle of the following week. It had been extensively viewed over the 24 hours that it was available on the News of the World's website, and had become available on other websites over which NGN had no control. You can see that at paragraph 7 of the judgment. The court, Mr. Justice Eadie, referred himself to the section 12.3 test, and reached the conclusion at paragraph 33, which is all I really wanted to refer to. He says, I'm prepared to accept the material has been seen by thousands of people around the world, and it continues to be available. Mr. Miller asks rhetorically, therefore, what can be achieved by an injunction in these circumstances? The court must always be conscious of the practical realities and limitations as to what can be achieved. I have in mind, of course, what was said in Douglas and Hello at 105, which we're familiar with. Nevertheless, a point may be reached where the information sought to be restricted by an order of the court, so widely and generally accessible, quote, in the public domain, that an injunction would make no practical difference. And then he says at 36, just very briefly, explaining his conclusion that the injunction would make very little practical difference. There's 4 lines down, 3 lines down. One may express this conclusion either by saying that Mr. Mosley no longer has any reasonable expectation of privacy in respect of this now widely familiar material, or that even if he has, it has entered the public domain to the extent there is, in practical terms, no longer anything which the law can protect. And this means we would have thought, although Mr. Justice Eadie doesn't at this point come back to 12.3, either that he's concluding that he's not likely to obtain a permanent injunction at trial, or the discretion to grant an injunction will not be exercised in his favour at trial because of the availability of the information in the public domain through the internet.
While you're on Mosley, do you want to say anything about the Strasbourg's approach to Article 10 in that case? Yeah.
Could I come on to that?
Of course.
We have to deal with the 3 grounds, and it comes up
Yeah.
with the 3 grounds in due course. The last thing I wanted to say about the law before turning to the 3 grounds pleaded in the notice of appeal is simply this. And it arises in connection with my learned friend's 3rd ground of appeal, which is the court was wrong to allow details of the information to be published, but might have allowed the name of the claimant to be published. There is an additional aspect to that issue, which it would be remiss of me not to mention, although I don't appear on behalf of the media as a whole or the public as a whole, which is the issue of open justice. The court has looked closely at issues about anonymising parties in civil proceedings. The leading authority is the Guardian case, which is at tab 16 in the bundle, and we all recall the judgment of the court given by Lord Roger in that case.
The famous what's in a name.
With the famous what's in a name and the alphabet soup case. And again, I don't draw any parallels between the facts of the case, but we would refer you, without taking you to them, to paragraphs 52, 64, and 65
Thank you.
in that judgment, which look at the public interest value to the media and the public of knowing the name of a person who is a claimant at a certain point in the litigation, where that person is seeking to withhold the name in order to protect his privacy. And we would suggest the Court of Appeal, whether it was right or wrong to lift the injunction in its entirety, was certainly right to allow the name of the claimant to be published in the light of the availability of the information in the public domain, which invariably and without exception contains his name. So I turn to the issue of whether the appeal should be heard by the court. Is there a point, i.e. an error of law at all? The court will be aware that we take the position that the test for an appellate court is that set out in AEA versus Associated Newspapers.
Equivalent to a discretion appeal.
Yeah. And so the 2 questions are, has the court erred in principle, or has the court reached a conclusion which was plainly wrong or outside the ambit of conclusions which the court could reasonably reach? We say the Court of Appeal's reasoning cannot be attacked on either basis, wrong in principle or outside the range of conclusions that could reasonably be reached on these facts. And this means we say that the claimant's application for permission is really, when you strip away the lengthy analysis of well-known principles about the law of privacy, really an attempt to reopen the case on the facts before this court. 3 supposed errors of law have been formulated. We assume that these are said to be errors of principle, so falling into the first category of point of law in the AAA case. Although I suppose that might only apply to the first 2 grounds of appeal, as pleaded, not the point about the width of the injunction, and whether the Court of Appeal was wrong to allow details of the story to be published as opposed to simply the name of the claimant. That, I suppose, it might be said, is a Category 2 error, a conclusion that no reasonable court could reach. I don't know. It's not addressed in those terms by Mr. Brown. Ground 1, we would suggest, is a little elusive, and the case was entirely reformulated in various respects by Mr. Brown's oral submissions today. But as pleaded, and to paraphrase Ground 1, it seems to us the point is that the claimant is saying the Court of Appeal failed to understand that there was still something to protect by the injunction, notwithstanding the wide availability of the information on the internet. That seems to be the core point. In other words, that some further protection from intrusion and harassment in this jurisdiction was of value, and that it didn't understand that possibility. It's said in the written case and in the grounds of appeal, the Court of Appeal did not properly take into account this point, a pleading which is often perhaps the last resort of the destitute when you're trying to establish a point of law. We say that the Court of Appeal did properly take that point into account and was well aware of it. This is the point that's said to be exemplified in the judgments in the CTB case where the application to relax the injunction was dismissed. And there's no quibble about the proposition of law. It's self-evident, it's apparent in the first instance authorities, it's apparent in the textbooks, and it's apparent in the Strasbourg jurisdiction. We're not here to argue, nor did we come before the Court of Appeal to argue all these high-flying points of principle that Mr. Brown raises about what the tort of misuse of confidential information or intrusion into privacy now protects. It protects publication of private information. It protects against other forms of intrusion. It's simply a question of fact. We came before the Court of Appeal because information had come into the public domain. And we now find ourselves arguing these points of principle that were never in contention below. We say the Court of Appeal plainly understood this point. To take an example, if you turn to paragraph 39, page 52 in the additional bundle.
Yes.
Lord Justice Jackson, whose judgment we would seek to defend on this and other points,
Yes.
says quite correctly, in my view, the correct analysis is that a claim for misuse of private information can and will often survive when the information is in the public domain. So he's distinguishing between the claim and the issue before the court, which is the prior restraint injunction. Depends on how widely known the relevant facts are. We would say that's right. In many situations, the claim for misuse of private information survives but is diminished because that which the defendant publishes is already known to many readers. Publication is an invasion. This is the republication under a relaxed injunction of facts already known, is an invasion of privacy and hurtful for the claimant, but is not as egregious as it would otherwise be. This does not deprive the claimant of his claim for damages, but it weakens his claim to an injunction. So the court understood perfectly well the distinction that my Lord Toulson makes between the effect of the availability of the information on the claim and the weakening of the claim to a prior restraint injunction against the media. Prior restraint injunction is against NGN, but because of the spy catcher principle, prevents the entire media, of course, covering the protected information. And it seems to us that what the claimant is really saying on ground one is that he disagrees with the conclusions the Court of Appeal reached on the facts regarding the balancing and the discretion to grant injunctive relief in the circumstances it found itself in, having directed itself properly as to the law, which it did at paragraph 39. There are some subsidiary issues raised in these paragraphs in the grounds. First of all, it's suggested, and it's been repeated here, that Article 10 rights are not engaged here. This is wrong. We've pointed this out in our written case at paragraph 23. The Article 10 right is engaged by the fact of the prior restraint injunction. That is an interference with the newspaper's right to freedom of expression within the meaning of Article 10.1, and so has to be justified under Article 10.2. This means in the jargon that Article 10 is engaged. The issue is how much weight does the right have in the balancing exercise involving Articles 10 and Article 8, Article 10 and 8 at the trial stage. The Court of Appeal fully understood that. See page 53, paragraph 47, Roman 5, where it refers to our right to publish. The restriction is by way of the continuing injunction. And it's important that that heresy is nailed. It doesn't make the claimant's case any less arguable or under Article 10, but it is a justification case. Then it's said the Court of Appeal effectively abandoned any attempt to protect the claimant's rights by the only means likely to be effective. We say this is a gross mischaracterization of the Court of Appeal's judgment. There is nothing in the judgment, when you read it, that would justify that criticism of the Court of Appeal. But this is not the statutory test. We have to come back to Section 12.3 and Section 12.4 all the time. That is what Parliament has mandated. The statutory test is not, you must make an attempt to protect the claimant's right by the only means likely to be effective. If it was, it would be much easier to get prior restraint injunctions, and Parliament, rightly or wrongly, has decided that this is not so. The test is in Section 12. Learned Friend has added what I would call ground 1A in his written case and in his submissions today, which is the suggested error at paragraph 40 of the Court of Appeal's judgment, page 52 in the additional bundle, where Lord Justice Jackson referred to Section 12, enhancing the weight which Article 10 rights carry in the balancing exercise. And it's said by Mr. Brown that it's axiomatic that the two rights start equally. And therefore, Lord Justice Jackson must have misunderstood and misdirected himself as to the meaning of the words particular regard to in Section 12.4. One needs to be very careful about this submission. First of all, because the Court of Appeal cited Ries in its first judgment. That is at tab 8 in the main bundle, and the citation is at paragraph 30. And it's important to remember we're coming back to look at the discharge of an injunction that's been granted on precisely the Ries basis, two rights being balanced and the court understanding that they start from an equal position. Moreover, in the decision of the Court of Appeal that we're looking at paragraph 28, that is Monday's decision, Lord Justice Jackson referred back to and incorporated the relevant legal principles in the judgment of the 22nd of January. And that covers the Ries principle. So he's saying something else here, rather than misunderstanding Ries. And it seems to us, one can argue about whether enhance is the right word and whether emphasize might have been a better word. But the reality is that what he's doing is simply drawing attention to the parliamentary mandate in Section 12.4a1 to have particular regard to that aspect.
Could you just go back, or can I just go back to your point on the engagement of Article 8?
10.
Sorry, Article 10. Article 8 is also engaged, they're both subject to qualifications. The European Court of Human Rights jurisprudence indicates that unless one is talking about a public figure in terms of a politician or someone like that, mere discussion of their private lives is not in the public interest within the qualification to within the language of these articles. So when one looks at freedom of expression under Article 10, this is a situation, isn't it, where in the interests of society, that sort of information should not be published. And equally, when one looks at Article 8, it's something which in the interests of society should be kept private. So, although I fully accept that both those articles are engaged, when you see how the balance works out on the facts of a case like this, there is no Article 10 right at all, because under the balance which you must undertake when you look at both paragraphs of Article 10, Article 8 will prevail, on the facts which are presently to be assumed in the light of the Court of Appeal's reasoning.
Well, the first thing to say is that the original judgment on the 22nd of January, paragraph 53, page 254, explicitly accepted that the claimant was a public figure.
That is not sufficient. That it merely. No. I mean, what do they mean by a public figure? Is the question.
No, I understand that.
Yes.
Sorry,
carry on.
Make clear that we had this argument at the first stage, and we did it logically and carefully, and we looked at Kuderek and established that the claimant was a public figure for a variety of reasons, which are dealt with in the evidence and in the unredacted judgment. Our case, as pleaded now, and I'll take you to it, is at tab 12 in the main bundle, page 291.
Which paragraph are we looking at?
I think I'm looking at 14, and we need to be a little cautious because it's in the confidential part of it.
I beg your pardon.
Sorry, we've moved on from the judgment.
Yes, sorry.
Where are we going?
Which page?
291.
291, thank you.
Page 291.
Right, thank you, yeah. Yes, I see.
Yeah. So, obviously I won't refer to it in open court.
No, I understand.
But see paragraph 14 and the
Yes, I
various
see.
subparagraphs.
But the trouble that I have with that is that, again, if you look at the unredacted Court of Appeal judgment, they have not, for present purposes, accepted any of that. On the contrary, they've negatived it.
They didn't accept, for the purposes of 12.3 exercise projection, looking at 8 and 10 and the evidence before them at that stage, that that we succeeded on the 12.3 issue, likely to succeed. But we are defending the case, and there is going to be a trial, and we will argue in front of the trial judge on the basis of evidence.
Yeah.
And on the basis of findings of fact made by the trial judge, which were not possible at the interim stage, that there is a public interest in this story for a variety of reasons.
No, I see the way you will put it. The difficulty is that it appears to me that in the light of material which we can't discuss openly in the unredacted Court of Appeal judgment, they have proceeded on the basis of findings that, in fact, would involve you failing on this point. And that is the difficulty which I have with their paragraph 53. Having made that conclusion, they then seem to go on and say that any, in their language, kiss and tell story about someone who is known to the public is admissible, which seems to be the exact contrary of what the Princess Caroline von Hanover decision of the European Court of Human Rights says, and a whole string of other European Court of Human Rights cases.
Well, everything depends on the facts. I don't want to go into what's pleaded, what the argument is, and what will be the contested factual issues. But we say there are aspects of this story that are in the public interest. And we lost in front of the Court of Appeal, and we accepted the defeat at the interim injunction stage. We didn't appeal it on the 12-3 test, the judgment in January. We lost on the balancing exercise at that stage. The Court of Appeal did not accept our main argument, which was that a false public image was being advanced by PJS and YMA. We intend to pursue that at trial. So we're concerned not to...
The issue in when you came back for the Court of Appeal, and therefore the issue for us, is a sort of initially a domestic question of whether there is a sufficient change in circumstances to justify the court departing from its original order.
Exactly. We weren't asking the court to review the original balancing exercise.
But there is a question which is raised as to whether the Court of Appeal's references, I think 2 or 3 times, to a limited public interest are consistent with its earlier decision, which on the facts seems to exclude any public interest in a legal sense, as opposed to interest of the public in a colloquial sense.
We say it doesn't. See page 53, paragraph 47.5, where Lord Justice Jackson reiterates what we take to be said in the first judgment, which is there is a public interest argument. There is a public interest in criticising, he only refers to one strand of our public interest argument, in criticising the conduct of the claimant. But it's of insufficient weight to win out at this stage.
So that was 47.5. Yes,
47.5, yes. It remains to be litigated. Could I just take you to the Hutchison case at tab 39 in the main bundle of authorities in the Court of Appeal?
Tab 39.
Tab 39.
Oh, well, yep.
At paragraph 29, this came from case of Terry, case about Premiership footballer,
yes.
not a public figure in the classic Strasbourg sense. And the argument was that there is a freedom to criticise even if the behaviour of the person you're criticising is not unlawful. Appears to have been submitted. This is the judgment, I think, of Lord Justice Gross in the Court of Appeal. On behalf of the court, it appears to have been submitted, the conduct of one person in private must be unlawful before another person could be permitted to criticise it in public. In a powerful passage, Tugendhat J. disagreed. This is in Terry, emphasising the importance of public discussion and the freedom to criticise. It's not for the judge to express personal views on such matters, still less impose whatever personal views he might have. That is not the issue. The issue is what the judge should prohibit one person from saying publicly about another. There is no suggestion that the conduct in question in the present case ought to be unlawful. It was an adultery case, or that any editor would ever suggest it ought to be. But in a plural society, there must be some who would suggest that it ought to be discouraged. Freedom to live as one chooses is one of the most valuable freedoms, but so is the freedom to criticise within the limits of the law the conduct of other members of society as being harmful or wrong. It is as a result of public discussion and debate that public opinion develops. This has led to a strand of cases in the privacy area where the debate is about publishing the fact of the relationship with the person other than the person to whom you're married, as opposed to details of it, and the freedom to publish that fact as a springboard to criticise the conduct, and maybe criticise the conduct, as we would say in this case, in light of the more general public image that has been created for the claimant. What you're allowed to publish is always an issue in privacy injunctions, but that is pretty settled law, that you can be a public figure and that you can be criticised how much private information you can put in the public domain to do it. You can be criticised for your conduct and for hypocrisy in relation to things that you've
well,
said
certainly,
in public.
But again, it depends what you mean by a public figure. I must say I'd understood the string of cases about Princess Caroline of Hanover as distinguishing between her public functions and her notoriety, and, for example, in one of them, in finding a rather tenuous link with her public functions when she didn't attend her father's funeral with celerity or when it would be expected, I think, if I recall it rightly. So that in relation to all private matters, her suggested amour and so on, that was regarded as mere kiss and tell.
Yeah, but the concept of a public figure has moved on a bit since the first von Hanover case. It's no longer necessary for the person to hold public office. Actors, footballers, England football captains, and so on have been held to be public figures. It's always a question of fact and degree. I can't go into the facts of this case, but if you go back and read the unredacted judgment and the evidence, the claimant's position does have some public-facing aspects, and he has assumed a degree of publicity for himself and a prominence for himself to speak about certain topics, which gives him a public profile beyond his relationship to YMA. And that was why the Court of Appeal decided in the first judgment that he was a public figure, and with respect, we would say it was right to say that. The question is, can the allegation of hypocrisy be justified on the facts? And the Court of Appeal in the first judgment felt that we didn't have sufficient evidence to do that, but I emphasise again, we are pursuing the point at trial, and it can't be prejudged. It would be a matter of evidence, full evidence at the trial. And it has been particularised at paragraph 14 of the confidential schedule. That's all I can do.
Well, we've seen what you've said about it in the schedule. We've seen what the Court of Appeal has the Court of Appeal has provision formed about it. And
well, all I was saying, it's
not decided against you in the sense that you can't raise it and develop it at trial.
Exactly. Nor is Article 10 not engaged.
Understand.
It's in the mix. The court had taken a view earlier on that it wasn't a strong right. And we respect and accept that, but we didn't go back to the Court of Appeal to challenge that, as my Lord Newberger says. We weren't appealing or reviewing its original decision.
You couldn't, but you
we were pleading a change of circumstances.
Exactly.
Yep. The second ground is the Douglas and Hello point.
Yes.
We say the observations of the Court of Appeal in this case, which the claimant relies on for its second ground of appeal, which you were taken to, tab 11, page 202, paras 256 and 257, are related to the facts of that case.
Yes.
And we all know what it concerned. It was a hard-edged breach of confidence and privacy case concerning publication of unauthorised illicit photographs when the publicity rights had been sold to the rival magazine. The claimant omits to mention in the written material, para 258, where the Court of Appeal made clear that it would always express its final conclusion in terms of section 12.3. What it was saying was that the factors in that case, looking back on what the Court of Appeal had decided at the interim injunction stage, would have led it to say that the section 12.3 test was made out. So these passages don't create any legal principle that applies in this case. If they did create a legal principle, that would be rewriting section 12.3. If there was a legal principle that you had to give injunctions to deter newspapers, or you had to give injunctions by way of prior restraint at the interim stage because our damages are too low in this country, that would be rewriting section 12.3. You can't do that. to the extent that the same points could be made on the facts in this case, you know, the claimant could say, in my case, damages will not be an adequate remedy. In my case, there's no real deterrent to tabloids publishing this sort of stuff. These points were all made by the claimant at the hearing on Friday, and they were taken into account in the judgment below. See paragraph 26 of the judgment below. So this is a sleight of hand. It's an attempt to create a point of law where there isn't a point of law.
Yep.
And then I come to Moseley. There's a variant on this point in the grounds of appeal at paragraph 29. This is the suggestion that the law under Article 8 in Strasbourg has recognised that the effective remedy provision in Article 13 of the Convention requires an interim prior restraint injunction in privacy cases such as this, rather than damages at trial, as a remedy to protect the Article 8 right. But they do not mention in their appeal, or their original grounds of appeal, the leading case in Strasbourg on this issue, which is Moseley versus the UK.
Yeah.
And it's the leading case because it deals with this issue in the context of a clash, precisely the clash we're looking at here between the Article 8 right and the Article 10 rights of the press. It's in the bundle at tab 38.
Yep. Oh, to remind you, you've got just over 10 minutes.
I'm grateful.
Mr. Moseley's complaint was that English law was defective because it had not required him to be given prior notification of publication so as to enable him to apply for an interlocutory injunction. And the Strasbourg court said wide measure of appreciation couldn't be said that English law was defective, but in the course of their judgment they looked at some important matters, including the role of Article 10 in relation to prior restraint.
Yes. Yeah, exactly. I mean, the argument failed, the positive obligation argument failed, creating a law of prior notification. But our point is the judgment of the Strasbourg court contains nothing whatsoever to suggest that in this context, Article 8 always requires a prior restraint injunction at the interim stage, where the material will constitute an interference with the Article 8 right. What it says is the important thing is the state has a system for protecting the Article 8 right, and that judgment's application of the system, the legal system, by the courts don't result in violations of that right. But it doesn't say you have to have injunctions. They're the only effective remedy. And one would have expected it to say that, since the point was you've got to have a law of pre-notification because it's the only effective remedy.
May we look at what it does say about Article 10?
Yeah.
It's paragraphs 112 through to 117, and perhaps 117 may be particularly relevant, but it starts 112 by, in familiar language, re-emphasising what is the role of the press.
Yes.
And then at 114, it draws the distinction between things which are capable of contributing to a general debate and tawdry allegations about private life, and develops that. And then that paragraph ends with words rather reminiscent of Sir John Donaldson. Focus must be on whether the publication is in the interest of the public, not whether the public might be interested. So thus far, it's summarising jurisprudence which has been established, has it not, for many years at Strasbourg. Then it does come to sanction for, in cases where there has been an intrusion of Article 8 unjustified by 10, and notes that sanctions have to be proportionate. Therefore, Article 10 can kick in at the sanctions level as well as at the right to publication level.
Exactly.
And 117 is directly pertinent, isn't it?
Yeah, that's a direct lift from the Observer and Guardian case.
Okay.
Yeah.
But could I also just take you to 100?
And finally, more readily justified in cases which demonstrate no pressing need for immediate publication and no obvious contribution to debate. What is said against you is there's no contribution to a debate of general public interest, you contest that, and that there's no pressing need because this relates to events which happened several years ago.
Yes.
And so far as debate of general public interest is concerned, you've dealt with that and say that's going to be dealt with at trial.
Yes, and please note also paragraph 131,
Very well.
emphasising that speech such as that in issue in this case undoubtedly benefits from the protection of Article 10.
Yes, very well.
But the point we're making is here, my Lord Coulson, that they're saying there's a hard-edged point of law here, with the effect of which is the Court of Appeal should have decided this case on the basis it had to grant a prior restraint injunction, rather than looking at the issue on the facts.
Yes,
and where you'd expect to find that, if anywhere, would be Moseley versus the UK. So, and then ground 3, we say, is purely a question of fact. It's the width of the injunction. It's a standard decision for the court that's heard the evidence, how much or how little of the information should be protected. But it is, in effect, a fallback position, which is if the name of all of the information can't be protected, it's the name of the claimant that should go into the public domain. We say no point of law of general public importance, and that the Court of Appeal's decision should be left where it is because they were the tribunal deciding the case on the facts. It was in effect a first instance jurisdiction. So just how many minutes do I have left? 5. Yeah. So on the Article 8 side, we argue, as we did below, the likely balance at trial is visibly different now. So is the case for exercising the power to grant a continuing prior restraint injunction by way of a permanent injunction. We say it's now surely unlikely, given the information that's available to the public, that a permanent injunction would be obtained at trial. That's what we said to the Court of Appeal, and they agreed with us about that. On the Article 8 side, we say the availability of the information impacts on the case for protecting the information. The impact on PJS and YMA at that stage at trial will have to be judged not only in light of their status as public figures in the entertainment industry and their experience of dealing with the media, both good and bad coverage, but also in light of the passage of time and the way the information has been available and in circulation by that stage for a long period.
You haven't mentioned in that context the children.
I'm coming to the children in a moment, but the claimant and YMA will have been able to prepare for not getting a permanent injunction. They will have been dealing with this information being in the public domain for many months, and we would suggest they can't pursue their lives between now and trial as if none of this has happened or is happening. It's noticeable that no evidence was filed by PJS and or YMA on the return to the Court of Appeal about how they have responded to or dealt with thus far the information that's now known to the public, or indeed what they propose to do between now and trial. They will surely have taken some steps, or will take some steps, to protect against the news spike that will occur if the information is published in this jurisdiction now or later, and that must include regarding the children. Though, as we know, they're not a trump card. Mr. Brown refers to K versus NGN and the principle of the rights of the children being a primary consideration, but Lord Justice Ward was right with respect to say that doesn't make them a trump card in this situation. This is not a public law case. It's a case about balancing rights. One has to be realistic about the possibility that publicity will occur and steps can be taken to protect the children. We also agree with paragraph 48 in the judgment, which the court will have read, of the Court of Appeal below, dealing with the position of the children very carefully and very specifically, namely that the information is out there on the internet. The concern that had moved the court before, given the age of the children, was them coming to the information on the internet if it was published by my client, but it is now there and can be seen by the children later in life as information that's been circulating on the internet. That may not be regarded by this court as desirable, but it's the facts now. It is the factual position. And we say the Court of Appeal took the correct and a realistic view about the position of the children. All this will only be more so by the time of the trial, and we say it's not open to the claimant's counsel to just keep repeating the observation of Lord Justice Jackson at paragraph 60 in the original judgment that the proposed story, if it's published, will be devastating for the claimant. The Court of Appeal has readdressed that proposition at paragraphs 47.2 and 47.3 of its judgment, and with respect, we agree. Much of the harm which the injunction was intended to prevent has occurred, that's 47.2, and the publication will no longer be a shock revelation as publication in January would have been, that's 47.3. On the Article 10 side, we've dealt with the public interest issues that will be pursued at trial regarding the damage to freedom of speech. We've dealt with that point. The permanent injunction is a more serious restriction on freedom of speech and will be harder to justify than an interim injunction. And lastly, we should not forget the discretion, because that is a separate issue. Injunction is a discretionary remedy. People, though not the mainstream media, not my client in published form, will have been discussing the case for some time knowing who the parties are. It will become increasingly difficult to justify a permanent injunction for this reason, and we respectfully agree with paragraph 47.7 in the judgment below, at page 54, in relation to the appropriateness of the discretion now being granted, exercised to maintain this injunction in the light of the information that's available to the public. As Mr. Justice Eadie acknowledged in Mosley, there are interim prior restraint applications that have to fail at this stage, applying section 12.4a1 considerations, and this is plainly one of them.
Thank you very much indeed. Thank you, Mr. Miller. Mr. Silverstone.
Nothing to add, thank you.
Mr. Brown.
Well, in the time that's available, can I start by just going back to the judgment to see if I can summarise my complaints?
Which judgment?
The judgment...
The judgment under appeal.
Yes.
Yep.
First of all, in relation to paragraph 39, nothing is said in terms there about any assessment of the possibility and extent of any future harassment. Indeed, Lord Justice Jackson expresses himself in terms which are much more consistent with there being present to his mind the question of what was already known about the facts of the prohibited conduct. It doesn't raise any question for consideration by the court of the need for protection from intrusion. And as I've already said in that regard, CTB makes the point that in relation to intrusion, prior publication, widely known facts on the internet may actually increase the need for protection. Dealing with paragraph 40, whatever was said by Lord Justice Jackson in his judgment in January, and I take the point there is a reference to Re-S there, in April it appears that Homer nodded, because if one looks at the way in which Lord Justice Jackson expressed himself in paragraph 40, enhancement is a meaningless word unless he intends it to carry the imputation that section 12 gives enhanced weight to Article 10 rights. And that's why he goes on to say that it raises the hurdle which the claimant must overcome in order to obtain an interim injunction. That latter point is simply not right, but it is consistent with his understanding of enhancement. Looking at paragraph 47.5,
Yep.
We say that the original approach in January of the Court of Appeal based on Kudurk in paragraph 53 of the January judgment was right, and that Lord Justice Jackson didn't pause to consider what the right to criticise people actually entailed. It's phraseology which one would expect to find in the context of defamation, but criticising people doesn't justify breaching their privacy. On effective remedy, first of all, we acknowledge and adopt that last sentence in paragraph 117 of Moseley is the basis upon which the court should have proceeded. In relation to efficacy, I ask you to bear in mind the way in which two examples of Strasbourg cases where only an injunction has been regarded as an effective remedy are to be found in our case at paragraphs 104 and 105. 104 is I and Finland, 105 Armoni Oni, and that's probably of the two the most important one, and I won't take time asking you to read the...
Fairly different facts, as Mr.
Well,
Appellant points out, but you say the same general principle.
Yes, one requires a practical and effective remedy. In relation to the naming of the claimant, allowing the name of the claimant to be published now would be unfair in the light of what the media have published already about the protected conduct, albeit without naming him. To name him now would have the 2 and 2 put together to make 4. The papers have no one to blame but themselves for that. I would adopt Lord Toulson's point on section 12.4 is about to become available, suggests in the short term. I'm about to go off to lunch. My wife is about to have a baby. All suggest a degree of imminence.
Well, that issue has arisen in a number of cases where there is due to be publication shortly.
Yes, the Thatcher Diaries.
And the Thatcher Diaries was one of them.
Yes, and I think there was a Barclays Bank takers case, Financial Times.
Well, presumably the words are used because the postulate is the injunction will be effective as regards anything which is already in the pipeline.
Yes, and that is why I said that the court shouldn't speculate as to what may happen in the unknown period before a trial. In any event, such speculation, and it wouldn't be evaluation, it would be speculation, to adopt the distinction of Lord Neuberger, would be inherently unreliable. In relation to Moseley, in CTB number 1, Mr. Justice Eadie explained why the situation confronting him there with publication on the internet was different from what had happened in the time of the Moseley injunction, which he refused. And the short point, forgive me while I find the reference, the short point, its authorities, tab 20, was that the internet publications took place after the order, not before. And that's paragraph 19, which leads on to the judge saying that a court should not abandon the protection it's given a litigant on account of widespread attempts to render the protection ineffective, a principle we say applies here. And at paragraphs 15 to 16, he resists the implicit suggestion that the court should refuse injunctive belief on the basis that defendants or others may simply ignore it. We say that is the correct principle, but it's not a principle that was applied here. Lord Justice Jackson seems to have taken the view that anything the court would do would be in vain. The points that Mr. Miller made on the facts I can deal with quite quickly. First of all, the facts which are contained in the Court of Appeal's judgment in January are anodyne. They're not intrusive or in any way sensitive. He referred to the US publication as being widely read. That we don't accept for reasons that I've given. The story, he said, took off here on the 6th of April. Indeed it did, because on Wednesday the 6th of April, the Sun and the Mail marched in step with the US publication and were complaining from the date of publication, the very day of publication in the States, that the injunction was absurd. He says, rather adopting the approach which I was dealing with a moment ago of Lord Justice Jackson, that there was nothing that the court, for example, the blog was not something the court can prevent. But as was said by Lord Templeman, the spycatcher, that doesn't mean that the court can't grant effective relief within this jurisdiction. Lord Templeman was one of the three in the majority in spycatcher, nor does it mean that the court is powerless to protect against future intrusion. Just dealing for a moment with CTB, even if there were no further details in the mix than have been published in one limited publication in the United States, that would still not justify the refusal of an injunction. As Mr. Justice Eadie says in paragraph 24 of CTB, intrusion can occur each time an allegation is published afresh. And that, of course, is also something which one finds in the McKennitt judgment. Thank you very much, unless I can help any further. And could I, I'm sure I speak for Mr. Miller, thank the court very, very much for arranging this speedy hearing.
We're very grateful, thank you.
Well, we're appreciate that. We're also grateful for the way in which the case has been prepared very quickly for us. Thank you both. I think the best course to take immediately is for us to rise for perhaps 10 minutes and let you know where we got to. So the court will adjourn now. I can't promise we'll be back in 10 minutes, but we'll try and be back fairly soon. Court's now adjourned. We will take time to consider this matter. We obviously will try and produce our judgment as soon as we can. In the meantime, the order made by the Court of Appeal, the 2-day staying order, imposing a temporary injunction, which we've already continued, will continue because it continues until we make a further order.
Yep.
So it is still in existence. If I don't think it's necessary to have any further order at this stage, but if either of you feel it is, perhaps you could say so now.
Doesn't occur to me.
Well, if it occurs to either of you, then get in touch with the court with a copy, obviously, to the other side. But at the moment, I don't think any order is necessary.
No, it's a stay on the lifting of the injunction.
It is.
You've continued to stay, and therefore you can continue it for a few
Exactly. But if there's any doubt or uncertainty, do get in touch. We're very grateful for the arguments that have been very clearly and concisely expressed, both orally and to those who were involved in the written cases in writing, particularly bearing in mind the speed with which the matter came here. We're very grateful to all concerned. Thank you very much indeed. Court's now adjourned.